Item number 1.
Made clear, Lord.
Yes.
My Lord, this PIL, my Lord, was filed, my Lord, because of the tardy execution of this national highway from Papunala to Nirjul. It is Naharlagan section, my Lord. This work was supposed to be completed on 7th of December 2024. So nothing was done. Your Lordships also sees, my Lord, even now nothing has been done. It also comprises of a flyover right through the township area. The flyover, my Lord, consists of 149 pillars. Now this work was awarded to one Udhil Shivam. All these days is on our court as well as me, my Lord, since we didn't know. Now Udhil Shivam has subcontracted the work to many parties. In that some have been cancelled now and all those sorts of things are going.
Who's the main contractor?
Udhil Shivam.
R7.
R7. No?
R7.
Yes. So, my Lord, last occasion, an assurance was given that within 2 months, the repairing work will be done. Now, as far as the flyover is concerned, only 64 has been completed, whereas it comprises 149. And the tools and machineries that I have seen, and today, my Lord, we have learned that because of, my Lord, the inaction of the principal contractor, my Lord, this delay are happening. So, what I am praying today, my Lord, these parts are going on, my Lord, all these works are going on. But the next occasion, my Lord, let the managing director of Udhil Shivam be present here, my Lord. Because the purse strings are being controlled by him. The bills are being paid to him. The subcontractor SPS, one firm known as SPS, is now constructing the flyover portion. One Tama Fabrication is constructing the road section. And he is doing nothing. Let him come before your lordships. But there is the understanding we have been also given. This
Who are
is
the subcontractors?
subcontractor.
Their party?
Yes, their party. Oh, no, my Lord, because
They're not a party.
Tama Fabrication was given only last month. Earlier was cancelled.
No, R7 has subcontracted to whom? How many? How many firms or how many companies?
Two.
They're not a party here.
They are also not a party. They also, subcontract also have been changed so many times, my Lord. When I filed it, my Lord, SPS was not a party. Because subcontract was not given to him.
SPS?
Tama Fabrication was a party. He was a subcontractor at that point of time. Now his subcontract has been cancelled. Now SPS has come in. But they are representing themselves, my Lord, SPS. On many occasions, they have been called before this honorable court also. Justice Habung knows.
TK, and earlier.
Earlier was TK. TK was a party, but his contract has been cancelled now. But the thing is, the principal EPC contractor, he can subcontract only up to 49%. But he has subcontracted everything. And because of his...
Who's supervising all this?
Supervising, there is the executive agency that my learned friend can
The
answer.
MOD as well as the state PWD highway.
MOD means Ministry of
Road
Transport and Highways.
And yes, highways.
No, contract has been awarded by whom?
By
Ministry.
through the state.
To the state.
Yes.
So, to ensure that the work is executed or the quality of work is maintained, somebody should be responsible.
There is.
Leaving aside this PIL, okay?
Yes.
PIL has come because somebody has said that this is not happening. Now, originally, who is supposed to supervise all these?
It is the state highway department as well as the agency appointed by the MOD and the MOD themselves also. There are three departments to monitor now.
Okay, so what have they done?
We are continuously monitoring the state highway as well as the MOD also. They are doing the inspection, but till now the work is very slow in.
See, the work has been allotted for construction of what, 4-lane highway?
Yes.
Yes.
Along with the flyover?
Yes.
Flyover.
But it is 11-kilometer stretch consisting of highway of 6 kilometers and 4 odd kilometers highway.
Flyover. Yes.
4.9. So 49 pillars, out of it 64 has been.
So roughly it's basically flyover as well as the road.
Yes.
And out of 149, 64 has been what? Erected.
Erected.
There were some issues.
Only the pillar part, matter.
Only the pillar
They
part.
admitted position that the progress has been very slow.
And December last year was the timeline for completion.
Extension till July 26 months.
July 26.
Yes. And Lord, so far as
Impossible.
fabrication is concerned, Lord, what has happened under the terms and conditions of the contract, Lord, the maintenance work, Lord, there was much emphasis during
Mr. Dubey, you are for R7.
R7. Lord, that maintenance work, Lord, has been allotted to Tama Fabrication. Lord,
No,
which is part of
what do you mean by maintenance?
the regular, maintenance, not the construction part. Lord, we have already completed part of it, Lord, but because of
No, construction, you have been awarded award work for construction, isn't it?
construction which include the maintenance part.
Maintenance. What do you mean by maintenance?
Maintenance, Lord, if some wear and tear and potholes are there, Lord, that also have,
On the existing road.
yes, on the what
Okay.
has been constructed. So to that extent, Lord, they.
So first thing first, to construct the flyover,
My Lord,
you have to erect pillars.
my Lord.
Yes.
Then only once you erect the pillars and the thing,
Yes,
then what do you call, the roads have to be, like
yes, service roads are also.
service roads have to be made.
My Lord.
But that includes, my lord, flyover is only up to 4.9 kilometers.
Mm,
Around 6 kilometers free.
Is that?
mm.
Total is around 11 kilometers. Flyover portion is only in around 4 kilometers.
No, what I was saying actually is that, you see, work is allotted and contractor has, to some extent, they have an agreement with the authorities and the completion time is there. And to ensure that the work is done properly and quality of work is not compromised, the various authorities like the MORTH and the government, state people are there. So why is that not happening?
Lord, if your lordship permit, Lord, on 17th October, Lord, we have been issued a cure notice of 60 days, Lord, which is going to expire on 17th of December, Lord.
What is
Lord,
that clear notice?
Lord, under the terms and conditions of the clause, if your lordship sees at page 586, the additional affidavit filed by them, Lord,
Hmm?
there is a notice by which, Lord, we have been asked. Otherwise, the next step is, Lord, regarding termination.
No, why
Lord,
should
we
you
are-
have be,
No, no.
why should you be asked to have that cure? Why should you wait for the cure notice in the first place?
No, Lord, not waiting, Lord. Lord, we are honestly trying to, Lord, expedite the things, Lord.
No,
but
no,
somehow
no,
or the
no,
other, it could not be done,
See, Mr. Dubey,
my Lord.
we'll come to that. Let me explain. I'm
Mal-
saying that ordinarily, when work is allotted, you are given a timeline, how to
Yes.
execute, and to what level you can subcontract.
Mal-
All those things are there.
Yes, yes.
You do it. Same time, authorities also have the responsibility of overseeing that work is
Yes,
done
yes. Under
in
their
a timely
supervision
fashion,
only, Lord,
and the quality of work is nothing.
my Lord.
This is not happening perhaps, which has prompted the petitioners to file this PIL.
To-
And the timeline was already December last year.
Yes.
And you say that
So by
July
that
is the
time-
extension of
yes.
26. What will happen within the next 7 months? 64 or 54 pillars
Yes.
out of 149. Do you think that much pillars can come up again?
The
The
calculation,
situation looks very grim.
Yes,
in
yes.
fact, you
Lord,
see.
Lord, I will not.
Without opening this, I'm saying
Yes,
that.
yes. Lord, in fact, me and
Once
my
we open it, I think we have to open many things.
My lord, in fact, me and my friend, Lord, in fact, before the proceeding discusses, we worked out the calculation if
3 years.
further things are
Further
not been
3 years
implemented, my lord,
at this
because
rate.
there is a peer cap. It takes 10 days, my lord, to work out. And for each day, if it's rotated, my lord, it will take huge number of days.
And
So
they
the
have
only
only
way
4
out is
numbers
that
of
we'll
days.
have to enforce it to a larger number, my lord. Otherwise, my lord, nothing is going to happen, my lord.
Yes. That is why I was making a prayer, my lord, that the managing director of the principal company be directed to appear before his honorable court, so that my lordship can direct them to, my lord, increase the tools and machineries. These people are just representatives, my lord. That is the difficulty.
So what, some status report was filed sometime back?
Yes, yes. my lord.
Yes.
On 2nd December,
Status report as on which date?
2nd of
On
December,
30th of November.
November.
Up to 30th of November.
30th of November.
my lord.
30th of November. So what does it indicate, the status report?
Status as per our
How much work has been done, how much percentage, and how much is remaining?
48%.
48% remaining, will be
52,
51.
51.
51. 49 completed,
48.
48.32.
48.32.
And the completion period that is given to them is up to 31st of July
July.
2026.
That's impossible.
That has become impossible. Now only 8 months left, but as per
My
the
lord,
calculation, it will take. more than
48.32%
32, my lord.
Yes.
as on 30th November
My lord,
25. That means a balance of 51.
51 point, yes,
51.68.
68.
Almost 50.
And extension,
Extension
31st July
31st of July
26.
26
when was this extension given?
was extension was given.
Sometime in March or April, my lord,
March.
this is.
Please give me a date. Not guesswork.
My lord, since this is not an adversarial litigation, my lord, you were talking to the representative of the company who is executing the work as well as the executive engineer. What I have learned is, if this is the number of tools and machineries they use, it will take another 3 years to construct the flyover. And if it is to be, my lord, shortened, then, my lord, the principal contractor will have to be, my lord, I don't know what word to use. He will have to be directed, my lord, and to, my lord, increase these tools and machineries. Otherwise, it will not happen. That is why I'm making that prayer, my lord, that the managing director of the Util Shivam be, my lord, directed to appear, be present on the next date. Because what they are doing is they're sitting at Bhubaneswar, my lord,
Exactly.
April 20.
doing nothing. The flyover is being constructed by somebody else. The road section is being constructed by somebody else.
Managing Director of Respond number 7.
Yes, my lord.
Yes.
The headquarters at Bhubaneswar.
Yes,
Yes, my lord. My lord, kindly, my lord, represent the fact. Even in terms of the contract also, only 49% he could have sublet. 100%, my lord, he has sublet, subcontracted.
So, in such circumstances, what is the penal action which can be taken by the authorities?
My lord, we will have no other option but to terminate them.
When will you terminate them?
My lord, that is
Work was allotted on which date?
January 21st, 2021. My lord.
about 26 November 2020.
Oh, 26 November 2020.
appointed date.
Agreement is 21st of January. Award was on 26 November 2020.
Appointed day was 8 November.
26 November 2020.
2020, my lord.
Appointed date was 8 December 2021.
Appointed date means?
The date from which
The
the work
counting
was,
starts, my lord.
work was to start.
8,
What is the date?
8 December 21, my lord, and period is 3 years. That's how 7 December 24 was the cutoff date, my lord.
So please make a suggestion. One, Mr. The Pagin has already suggested MD should come and tell us what he plans to do. Any other
I
suggestion?
think my learned friend would be agreeable to that, my lord. I think that is,
I would also suggest that only. Let the main contractor be present. Because these are, the SPS is a representative of this Udil Shivam, the main contractor.
Now, apart from the contractor, who else should be there?
The representative of the mort.
MRTH, but they have been, MRTH and the representative contractor SPS has been present before this honorable court on many occasions.
Who is the representative of MRTH?
MRTH was Mr. क्या नाम था? Subhash Chandra, one Subhash Chandra.
What is he?
Regional officer, I think. Regional officer.
Regional office.
Regional officer, MRTH, based at Tezpur.
Chandra.
Yes.
But, my lord, it is learned that he has been recently transferred out.
So we go by the designation then.
Yes, regional officer.
Transfer हो गया क्या?
हो गया वो।
He's based in Tezpur.
Tezpur. Yes.
Then from the state,
State, the
Executive is already here, man.
is already here.
the executive
Engineer.
engineer. What
Hi.
is your good name?
Hage Tajang.
Tajang, Hage Tajang, sir.
Hage
Sorry?
Hage Tajang.
Hage Tajang.
Hage.
T-A-J-N-G, yeah.
H-A-G-E.
H-A-G-E,
Hage.
T-A-J-N-G.
Tajang.
T-A-J-N-G.
T-A-J-N-G.
J-N-G. Yes, sir.
Hage.
Tajang.
Tajang.
J-A-N-G. Okay. You are the executive engineer,
Right, sir.
state PWD.
Right, sir.
PWD highway.
Highway division.
Highways. Highways.
Highways.
Nahadman highway division. Na?
Nalagan Highway Division.
Nahadman highway division.
So what exactly will be your role in this construction and what have you done so far?
Right, sir. We are representing MOD on behalf of MOD, State PWD Highways. We're looking after all the national highways under MOTH.
Mhm.
So, it's like this project is under EPC mode. So there's an authority engineer who is appointed by the mode to supervise and monitor the project, sir.
Mm.
Right, sir.
Who's the authority engineer?
Authority engineer is ACOM.
Ecom.
Yes, sir.
Okay. Ecom. How do you spell that? Ecom.
It's just a short name. ACOM. A-E-C-O-M.
A-E-C-O-M.
O-M.
What is the full form?
There's no full, just a name, sir.
Oh, it's a name.
Name.
It's the name of a person.
Consultant. No, consultant.
It's a consultant.
Right, sir.
It's a name of a firm.
Yes, sir.
Name of a firm.
Right, right.
And
I can give the name ACOM Asia Company Limited.
mm,
That is,
okay, so
right.
as the executive engineer for the state PWD highways, what would be your role?
My role is overall supervision, monitoring, supervision. Right, sir. Along with the authority engineer. Authority engineer will report to us. Whatever their findings are, design, approval, all those monitoring, day-to-day monitoring they do, and they report to me.
Okay.
And they are usually they are a fully competent group of engineers with that design directors, proof consultants, safety consultants. There's a group of engineers, consultant. So those design proofing, vetting, and approval are based on two tier. So basically, EPC contractors themselves have their own engineering group of engineers, design consultant, proof and safety consultants. Then they, whatever proposal they need, they give to the authority engineer. The authority engineer they vet, then they give the approval, and they send the recommendations to us, sir. In turn, we send to MOD like that. This is our role, sir.
Okay, so now the work was supposed to be completed by December last year.
Right, sir.
It's not happening.
It's not happening.
And number two is that the contractor has subletted almost all the work to somebody else, which is perhaps against the agreement which was reached. 49% of the work could have been subletted,
Right.
but they are subletting everything to everyone.
Right, sir.
So under the circumstances, you are supervising otherwise.
Right.
So what action have you all taken?
Six EPC contract provisions 49%. They can sublet up to 49%. Then 51% they have to own the project, sir. So what they have done earlier, they subletted to PG Engineering. Then last October, when we issued a queue period notice, then they terminated this one subcontractor and they brought in SPS, which is doing now the flyover portion. And again, they have subletted around 35% to SPS and 14% to TK
Mm.
again. So basically on this own partnership, this project was running on till now. So basically then they have appointed that Mr. Abhishek Kumar, who is the managing director of SPS as their authorized signatory.
Mhm.
So both ways they are, I mean, he's representing himself through SPS. You could answer. So on our part, when we see out, he's on the ground through Abhishek Kumar.
Mm.
Since they have appointed him as an authorized signatory. So he's fulfilling all the criteria of the agreement. And they are binded by the agreement, sir.
No, but what sort of agreement is going on when work is not progressing at all?
Right, sir.
And we are all bystanders watching what is happening. We don't know what is happening.
Madam, that's why this main contractor, Woodhill Shivam, the managing director is nowhere present. What he does is he sublets the contract.
Hmm.
For example, the SPS is doing the flyover portion. Now, the Woodhill Shivam is being represented by the SPS, the representative of the SPS. The main managing director is nowhere. He is lease border. Now, therefore, we want him to be directly answerable.
It's based in Bhubaneswar.
Yes.
The appearance itself, by itself, may not be very helpful. It should also appear with something, what they plan to do, how they plan to complete this work.
Yes, yes.
Yes.
That has to be
Yes.
there.
Once he appears in this honorable court can
Hmm.
ask some queries and maybe direct. But I don't personally, my lord, I don't want the cancellation. It will only, my lord, defer the work.
Hmm.
Somehow, if this work gets done, and since it is not an adversarial litigation, this suggestion has come from that side, my lord. That the managing director Woodhill Shivam needs to be present here, my lord.
Mhm.
I will say.
Otherwise, I could have said, what are the authorities doing? Why don't they cancel? Why- That doesn't help anybody. Otherwise, my lord, maybe the 30 citizen reports have been filed. It's almost the same every 2 weeks.
Okay.
Let the manager be managing director be present, and then this court on that day may direct that if in the event of failure, then the authorities will be at liberty to terminate the contract itself.
Then the next is 2-3 today, authority.
File what is. Authorities will be at liberty to terminate
हमको तो बोलने दीजिए हमको तो बोलने दीजिएगा हमको थोड़ा 2 लाइन बोलने दीजिएगा सर को बोल दीजिएगा My lord, sir, excuse me. I have given in the affidavit also.
Hmm.
So in the schedule H on behalf of authority side,
Hmm.
as per the EPC agreement contract, we have issued the cure period notice on October 7th.
No, you
17th.
issued what?
Cure period.
Cure
Cure period is the time we give to the contractor
Hmm.
to cure all the there's deficiencies in the project.
Hmm.
It might be this slow progress, whatever may be.
Hmm.
So based upon various defaults on Article 11, 23 and various defaults, we have issued the cure periods giving a time of 2 months that
Hmm.
falls on 17th December. This
17 December.
17th days now.
When did
upcoming,
you issue it?
upcoming
When did
October
you-
17th.
Sorry?
17th October.
October.
Yeah, giving the timeline of 2 months.
Hmm.
So that timeline ends on December 17th, upcoming 17th. This, so authority will have to act, and we have, during the cure period, we have held various meetings, which has been duly recorded, and I have annexed as an Annex 2 and 3 in the affidavit. Whatever is the weekly
Cure
daily
period
process.
is, cure period is given by the authority engineer.
No, not authority engineer, they recommend. Then authority, based on their recommendation analysis, we issue the cure period notice to the EPC contractor.
Who has issued the notice?
Notice, chief engineer,
Chief engineer,
right, sir.
highways.
Highways side, sir. So this is Annexure 1,
Cure period for 2 months.
2 months.
And within this 2 months, what is he supposed to do?
He's supposed to cure the deficiencies.
Deficiencies.
And he has to mobilize to decrease the gap between the progress. So right now till October and November 30th, his percentage was 48%. And as per the work program, whatever he has given, he should have been achieved till now 58%.
58%.
Right. So there's a difference of
10% behind.
10% behind. So December it shoots up to 68%.
Mm.
So the gap is increasing.
Mm.
So now contractor has to devise and mobilize his resources according to the reduce the gap,
Mm.
the progress deficit.
Mm.
So that notice is given by the authority.
Mm.
Fulfillment of the contract. This one.
Now, supposing the cure period is not utilized effectively, then what
Right,
will
sir,
happen?
right.
What will happen?
Yeah, 17th. That's why, sir. On 17th, if they fail to cure the whatever the deficiency there,
Mm.
then we will give a notice to intimate regarding the termination based on clause 23 of the CA contract agreement.
Okay.
Then we'll give a 15 days notice to him.
Mm.
So he will he will be given a 15 days time to file whatever in his defense.
Mm.
So then we'll analyze. Then we'll recommend to MOD.
Mm.
The MOD, based upon their analysis, if they approve for termination, then we'll proceed for termination.
Okay.
Right, sir.
Mr. Dubey is for R7. So how much work have you done?
That is the status report not indicated.
Hmm?
What has been stated is the correct position. 48% at that.
So although the subcontract has been given to many others,
My lord.
ultimately it's the respondent number 7
Yes.
who's responsible.
Yes.
What is the financial progress?
Financial is 45.7. I have given here, sir. Page, यहाँ पे page ना? यहाँ पे. हाँ, यहाँ पे. यहाँ पे. 45.36. 36. हाँ, हाँ.
580.
Page number 580. Yeah, mark me.
My lord will find at page number 580. The affidavit filed on 2nd of December.
He is entitled to sublet only 49%.
Right.
But here is the case where he has sublet
No, sir.
more than 49%.
No, no.
No, okay.
As per contract,
Rest of the 51% is still with him,
it's still with him.
but he's not doing anything.
He's nothing, sir.
Actually not doing anything.
Hmm.
Because SPS, the managing director of SPS, which is another company, is the representative of the EPC contractor. That is how they are working. That is why I say, though my learned friend says he's representing respondent number 7, he's actually not representing respondent number 7. He's representing SPS. That is another entity which is not even a party here. He came to the picture only around a year back.
Where's your writ petition? Mm, Mr. Pangin,
My lord.
please come to page 42.
42, my
This is the NIT. NIB.
Yes,
We're concerned with which work?
package B,
Package B.
yes.
But which one is the package?
My lord, on the first column, my lord, name the work four lining of Itanagar Bandaras and NH 415. 40 is a package B, my lord.
Okay, package B, this one. This is the estimate cost.
Yes, 426.88. Completion period was 36 months, maintenance period 5 years thereafter.
Mm.
Package C has been completed.
Next.
Last time का estimate sign करेगा बोला अभी तक किया ही नहीं उसने।
हम लोग को नहीं करने का है, हमको consent या record भी चाहिए। वो भी
Respond number 7. Where's the election?
consent तो है, ये तो record ही है। मैं बोला हमको कर लेना।
There is nothing.
And they already consented for. उसने record किया हुआ है।
Working issue. You know what?
कुछ फर्क नहीं पड़ता। कर देने से करना से।
वो तो
Only call him. When do we pick it?
क्वेश्चन
ये सब कुछ का कुछ नहीं करेगा कुछ नहीं
Your
कुछ नहीं।
period is given until 17 December.
how does it matter? मैटर ही नहीं करता।
Sorry?
कुछ नहीं करो मत करो
लेकिन करना चाहिए ना।
उसको तो अपडेट कमिट करता हूँ
मोस्ट ऑफ द रिकॉर्डेड है।
साइन एकदम कौन सा बाहर कौन जाओगे
कॉन्फिडेंस मिलेगा ना।
What is the What is the Follow.
एक्स्ट्रा कॉपी
When could you fix it? But actually, you have to go to next. January.
मेरा पड़ोस में इसका दिया होता है एपिडेमिक फॉर्म नंबर
पीडीएफ कराया क्या?
प्लीज आपका सीडी ऑफिस में ऑफिस में
मुझे शेयर कर दीजिए।
Should you ask him to give us a longer
उसका
office में
मैं फाइल अप हो रहा है
Okay, he's right. This PIL has been filed by the petitioners in view of the very slow pace of work being executed by the respondent number 7 on being awarded the contract work for 4-laning of Itanagar to Bandardeva section of NH 415 from KM 40 plus 430 to KM 51 plus 735 bracket package capital B for an estimated cost of rupees 426.88 crores. Stop. As per the notice inviting bid, the completion period is fixed at 36 months with the 5 years period as the maintenance period. Next para. Court is informed that the award of the contract work was done on 26/11/2020 and an agreement signed between the parties on 21/1/2021. Despite the timeline given for the completion of the construction work, the court is informed that as on 30/11/2025, only 48.32% of the work has been completed, and thereby leaving 51.68% of the work remaining. Stop. It is also brought to our knowledge that the work completion time has been extended till 31/7/2026. Next para, Mr. D. Pangin, learned counsel for the petitioners, submits that with the amount and number of tools and machineries being engaged by the contractor, the work is not likely to be completed for the next 3 years. So he also submits that while the contractor is permitted to sublet only 49% of the work, but it appears that he has subletted almost 100% of the work to subcontractors. And the same has contributed not only to the very slow pace of work being executed, but the work being of a low standard. Next para. Mr. Hage Tajang, the executive engineer of the State Public Works Department, Naharlagun Highway Division, is present in person, and he has informed the court that the contractor has been issued a notice for curing the defects on 17 October 2025 for a period of 2 months. Stop. He has informed the court that the contractor has to cure the shortcomings and defects within the given period of 2 months. And if the same is not done, a recommendation would be made through the authority engineer to the Ministry of Road Transport and Highways for taking necessary action against the contractor. Next para. We have also been informed that out of the 149 pillars to be erected for the proposed flyover, only how much? 64 pillars have been erected till date, and thereby leaving a balance of
75.
just calculate
70,
75.
80.
Foundation
85.
Foundation 55,
85,
foundation 85,
64 remaining.
64 remaining.
64 pillars, leaving a balance of 64 pillars to be erected.
क्या होगा?
Stop. Considering the timeline being extended till 31/7/2026 only, it appears that it would definitely pose a challenge to the contractor to put up the balance pillars, let alone complete the flyover itself. of Mr. D. Pangan, Learned Counsel for the petitioners, submits that in view of the manner in which the work has been executed half-heartedly, comma, it is not known as to when the work would be completed ultimately. So while such is the position, he submits that the public in general has been caused great inconvenience to fly to commute in and around the construction site. Next para. Having regard to the above position, we are of the considered view that the contractor concerned, that is respondent number 7, through its managing director, should personally appear before this court on the next date fixed, along with the up-to-date status of the work being executed, and also along with the manner in which the work is sought to be completed. Of the same should be filed by way of an additional affidavit on or before.
Second, 19th.
We'll have to go to next year because
Well, let it be, come up on 22nd, let the affidavit be filed on or before 19th.
in December.
Yes.
There was already an order with honorable
Hmm.
court actually to list the matters every 2 weeks.
Hmm.
Honorable court was
Yes.
monitoring it.
See, that cure period is given for 2 months, isn't it?
Yes.
It is due to expire on
17.
17.
It will be expiring on 17.
17. So it'll be preferable to have after that date only.
Yes,
Yes.
on
Then
19th.
So
22nd.
the working days are very limited, you see. The working days up till 24th.
Yes.
So we were thinking in terms of January, just after the reopening.
Why not,
Let it be on 22nd.
Let it be before the vacation once at least. So that
Blood, let it be in reopening, blood. That will also give us time to, blood, so far as proposal is concerned, blood.
no, they have been given ample time already.
Yeah,
At least before the year ends, at least let them come before this honorable court and tell this honorable court what they propose to do, madam. Your period expires 7th September.
Working period. Utilize the working period.
Because the working period is also very less. It's only up to March.
Not March. No. Might be January, the rains also.
Yeah. And the affidavit file
on or before 19.
19.
And then the matter be posted in
December 22.
22. Yes. Let the affidavit be filed on or before 19 and the matter be fixed on 22nd. Monday.
All right, Mr. Dubey, you please convey.
My lord, I'll do it.
The affidavit be filed on or before 19th of December.
My lord. And your lordship is fixing on 22nd.
Yes, 19th of December, 2025.
In fact, my friend is right on one count because the working period is also going on. Lord.
Mm.
That's why Lord, there should be some
Peak working period.
peak working
Peak working.
time.
Let the matter be listed again on 22nd of December,
Fine.
2025.
All right.
I said 19th of December, no? With a copy of the same to all the parties concerned.
My lord.
List the matter on 22nd,
Obliged.
right?
Obliged.
Lordship, I'd like to mention item number 10 to 12.
Yes,
Lordship, here we have to file affidavit, Your Lordship, some time may be given,
10 to
File.
12.
10 to 12.
How much time?
After vacation, Your Lordship.
Mr. Soki is there?
I'm for the petitioners.
Okay. If I say 3 months, then it goes 3 weeks, that means it comes after vacation.
Yes.
Okay, as paid for by Ms. R. Basar, Lanet State Council. Further 3 weeks time is granted to obtain instructions and to file counter affidavit. List again immediately after the opening of the court after the winter session,
Obliged, Lordship.
winter vacation. Huh? That's it.
Lordship, I have to mention item number 4.
4.
Yes,
Yes,
I on behalf of Tito Police leading counsel and is out of station due to some urgency. Lordship, therefore, this matter may be fixed on 9th, that is Tuesday, Lordship. Next
Tito
week.
Pu.
Yes, Lordship.
Okay, as paid for on behalf of Mr. Tito Pu, Lanet Council for the petitioner. List the matter on
9th, Lordship.
9th of December.
Yes,
2025. All right.
obliged, Lordship.
My lordship, I beg to mention item number 17. In this, we haven't received our Paravas reply, so we need 2 weeks' time, my lordship. I have taken consent from the petitioner.
Okay. As paid for by Ms.
K. Wangmu.
K. Wangmo, learned government advocate, appearing for the state respondents. For the, how much time?
2 weeks.
2 weeks time is granted for filing counter affidavit. All right.
Item number 1.
Yes,
Yeah, I have played your. Well, in this rate petition, petitioner is advocate and social activist. He has been working in different issues in Arunachal Pradesh, and he has been attending many meetings and conferences in different part of the world, taking the issues. But then suddenly, what happened on 4/10/2025, when he was boarding for the Dhaka for some conference, that is the Regional Infrastructure Monetary Alliance Conference, he was invited for that particular programs. But then, without any notice, without any information, suddenly he was shocked and surprised. He was offloaded from the airport, and he was not allowed to travel to the Dhaka. Now, as per the record, we have filed RTI to find out the reason why he has been restrained and why he has been offloaded from the airport, and why he has been restrained to travel to different part of the world. So, well, this is I will just take to this Annexure 2, page 15. It clearly shows that he was uploaded from the airport and he was not allowed to travel to Dhaka. Your Lordship, may I see the page 15? Page 15 is the air ticket, and they have with the seal uploaded, and this is done by the immigration department. So now prior to this, there is no any informations, nor notice to the petitioner that he should not travel, or there is any cases where he is not attending, that there is no such cases, Your Lordship. Now, if you see, as per his case record, there is only one case pending against him that is related to the order saying that the Deputy Commissioner of Upper Siang, he said that he has violated the prohibitory order, engaging some group of people who were protesting in the dam site. That was the only issue in the case, and they have lodged a FIR. That is, FIR is pending before Upper Siang. But in that related case, there is no any issue. He has been cooperating with the investigation. He has attended before traveling to Dhaka on 28 September and on 2 October. There's no any whisper that you have been restrained to travel. There is a restriction not to travel. There is no such information even from police department. But suddenly on 4th, when he was in the
It was
airport,
uploaded from on 4th.
yes, on the 4th,
Any other date? Only one date.
only one day.
And what was the reason?
Reason, they have not given any reason order,
You
saying that as per
some-
bubble information from the immigration department, they said that there is some notice from the police department.
Lookout order.
Lookout,
We have a lookout order
we
here.
don't have, my lord.
Okay.
In fact, there is no such notice, my lord.
Hmm.
There is no such notice against him. We have not received anything, any notice related to lookout notice, because there is only one case pending against the petitioner.
Where have you mentioned that?
Yes, my lord.
One case pending against you?
Yes. In paragraph 6, paragraph 5 is related
PS
to,
case.
yes, my lord.
Bowling PS case 10 of 2025.
Yes, 10 October
Registered
2025.
on what section?
Under section 3, subclause 5 of BNS and 223. So one is,
Where is that?
yes, my lord.
Where have you mentioned that?
Yes, it is, your lordship mentioned the FIR. I'll just take to the FIR. It's in page 16. It is starting from page 16. And then the type copy is in page 17.
Hmm.
Section, my lord, it's mentioned.
Date and time of FIR 28/5. Correct?
Yes.
Then section is
Section is 3, subclause 5 and 223 of BNS.
piece of clause 5. Then 2 to 3.
Yes, my lord.
So there's some typo error also.
Yes, my lord.
Hmm? Instead of 3/5, it's written 350.
Okay, my lord. It's a 3 plus 5.
So only this thing is pending against you.
This is the only thing this
And
case
what-
is.
Why have you filed this writ petition, criminal writ petition? For
My
what?
lord, criminal petition, my lord, this is a clear violation of Article 21, Article 19.
So what relief are you claiming?
We are claiming that, my lord, your lordship may see our prayers, my lord. One is that any lookout circulars
Hmm.
that may be issued by the authorities is being arbitrary, illegal, ultra virus, being a violative of Article 14, 19, 21. It should be, it should not be enforced, or the petitioner should not be restrained to travel any part of, if he wants to travel any part of the world. Because if there is no any case against him, there is no any violation of any rights. So the petitioner cannot be just simply, there is a one case against him in the FIR. That also simple allegation is that he is leading the protesters in that dam site. That cannot be a ground for restraining the person to travel any part of the world. Because it is his personal liberty. He has a right to travel a different part of the world, and he has a right to attend any programs. This is also violation of right to free expression, my lord. And Article 21, right to life, right to liberty, my lord. This is a complete violation of constitutional rights.
Yes, Mr. Kato, anyone?
Madam, I'm for the respondent number 1 and 2, madam.
Oh.
Same as like the petitioner, madam, even we are not having any information. So this issue notice.
Notice. Is this connected to item 6?
Yes,
Connected to item 6?
item 6, madam, is, yes, madam, almost similar, madam. Same issue, madam.
Damn protesters.
The protester, madam.
Huh?
Some violation, maybe, madam, under such terms and conditions, madam, the bail may be,
Alright.
was to them.
Heard, Mr.
Esmo.
Isom.
Yes.
Esmao, sorry, Esmao. Esmao, learned counsel for the petitioner who submits that by filing this petition, the petitioner seeks for appropriate writ against the respondents.
So, damage,
Directing them to not to issue any restraint order or further lookout circulars against him, as was alleged to have been done, due to the fact that the petitioner was offloaded while boarding a flight to Dhaka on 4/10/2025 at Kolkata. Now, the learned counsel submits that only case reported against the petitioner is the FIR which was lodged on 28/5/2025. Under Siang PS Boleng Now, in Siang PS Boleng, under sections 3(5) and section 223 of the BNS, next para in view of above issue notice, returnable by 4 weeks. Mr. M. Kato, learned DSGI accepts notice on behalf of respondent
1 and 2, madam.
numbers 1 and 2, while Mr. S. Tapin, learned senior government advocate, accepts notice on behalf of respondent numbers 3 and 4. Notice is therefore complete. Extra copies be furnished within 2 working days. List again after 4 weeks.
All right.
Item number 2.
Contempt.
This is a contempt.
Mr. Mao, what about section 20? There's a limitation for filing contempt.
Yes. But then,
You are filing after more than 1 year.
we have served the copy, and as per the your lordship's direction is that the implementation has to be after 4 months after receipt of the order.
4 months.
Yes, as per the directions, my lord. May I just take
So
to
when
the-
did you serve?
where we have served on 28. Just go to that order. my lord, just let me.
The judgment and order is dated 18/7/24,
18/7/24, yes.
and compliance has to be within 4 months of receipt of the copy. And when did you serve the copy
Yes,
of?
your lordship may see the annexure, page 187,
23, you have served on 23/8,
23 yes, 2024.
correct? So 4 months thereafter will be what?
Yes, 4 months has to be count
Will
from
be
here.
end of December
Yes,
24. You're filing this in December 25.
December 24. December.
You're aware, isn't it? Otherwise, about section 20.
Yes, my lord. 24, my lord. Industry.
So you examine this aspect and make your submission. With-
May I go, yes, may I calculate that?
Hmm?
May I calculate that limitations? Sir?
Yes, on the prayer of Mr. S. Maul, Honored Counsel for the petitioner, matter stands adjourned. We will list it again after a week
My lord, date may be fixed, 18th may be fixed on 18, my lord.
on 18. In the meantime, Mr. S. Maul shall examine as to whether the instant contempt petition is debarred by section 20 of the Contempt of Courts Act.
Obliged.
Item number 3.
Yeah, your lordship. Lordship, as per the last order, I was supposed to seek instructions.
Okay, this is that election,
Yes, your lordship.
correct? Yes. What is the instruction?
Instructions, your lordship, only the letter which was,
Mm.
as I
Has
have
been
mentioned.
constituted?
No, not yet.
Not yet.
Not yet, your lordship.
So what is to be done then?
Your lordship, as per the provisions, the election petition is to be filed within 30 days from the date of declaration of the result after conclusion of the election process, your
That we have
lordship.
seen already.
Lordship. So,
Are you saying that at this stage, there's no necessity of constituting the election tribunal?
that, no, it's
Since the election has not taken
Since-
place till now?
My lord, this court has inherent power to interfere, especially in this case. Since rejection was made without a valid reason, and the presiding officer has committed a gross violation to the election code of conduct by themselves, and therefore this court, if this court has not intervened, then my fundamental rights and my democratic right will be totally curtailed, and it will pass a wrong message.
Where is your representation? It's pending, isn't it?
Yes, lordship, it's still pending there.
Where's that?
Page number
6 series, returning officer. So we'll do one thing, we'll direct the returning officer to dispose of the representation within a time frame. Mr. Tapin and Madam, what do you say?
If, so far the dispute is concerned,
Hmm.
this election dispute. And that authority, returning officer, he has no authority to decide on that issue, Lordship. This dispute has to be get settled through the Lordship election petition only. And the result is likely to is set to be declared on 20th of December, Lordship. And constitutions of this tribunal is concerned, Lordship. There is a period, Lordship. Till 20, within this period, tribunal can be constituted, Lordship. And from 20 to 30 days, Lordship. Within that period, this election petition can be filed, Lordship. What I'm submitting is that, Lordship, this subject matter has to be dealt by the tribunal only, Lordship. Now, if Lordship direct the returning officer to consider the representation, it will amount to, Lordship, considerations of the election dispute. But that's my, Lordship, submission, Lord. Otherwise, also, Lordship, see, the money received, Lordship. It was, this is dated only 26/11, Lordship. On a day of scrutiny, it was submitted, Lordship. It's not that, Lordship, he cleared the dues prior to date, Lordship.
Where's the bar?
Nomination.
Where's the bar?
For that, Lordship, we need to take instruction from the authority, Lordship.
No, at the phase of it. Today is the scrutiny. Today somebody says that I've cleared.
Because these all
that he'll come tomorrow and say that I've cleared.
That at this stage we don't know, because we need to take instruction from the authority, because nomination has to be was filed on 24th, Lordship. Whether these documents are to be submitted along with the nomination or not, that stipulations are not before us, Lordship. If that stipulation is there, Lordship, then automatically, Lordship, we are barred, Lordship.
Lordship, other candidate, there also certain issues was there. They were considered. But in my case, they have the arbitrarily and maladroitly rejected my this nomination paper. And this court can intervene. There is judgment. I want to place, I'm about to place the
Let's see
judgment.
the judgment.
This is the judgment. This court can intervene in such circumstances that the judgment is the Lordship. Ramakrishna appellant versus presiding officer or assistant registrar of cooperative society. Since cooperative society comes under state. So this was decided in Bangalore, decided on 11/6/1991. Tweet appeal number 2487 of 1991, Lordship. Here, Lordship, in this writ appeal, following question of law arise for consideration. Whether this court has no jurisdiction under Article 226 of the Constitution of India to intervene with any illegality committed in the course of the holding election to the office of any authority, anybody, which is regulated by statutory provision. If the law provides for filing an election dispute challenging the legality of the election of the candidature declared elected. If the answer to the question is in negative, then under what circumstances this court should exercise or should decline to exercise its ordinary jurisdiction under this under Article 226 Constitution, Lordship. Here, brief and this the undisputed fact of the case are this: the second respondent in the Taluka Agriculture Produce Cooperative Marketing Society is a cooperative society constituted and functioning under Karnataka Cooperative Society Act 1959. The act of for short, the area its operation is Bangalore North Bank. Under Section 16 of the Act, the other cooperative society can admitted as its member. The Agriculture Cooperative Society so-and-so established at various places in the Taluka are its member. Matter relating to election to the managing committee of the society are regulated by the provision of the Act and the rules framed thereunder. In respect of certain classes of cooperative society, Section 29(5) of the Act empower the state government to prescribe one of the condition for eligibility of the election if it reads 29C, disqualification for member of the committee in case of cooperative society, marketing society, consumer cooperative society, and such class of or classes of cooperative society as may be specified by the state government by notification in the official gazette. No member shall be eligible for being appointed for elected as a member of the committee of such cooperative society if he does not fulfill the minimum qualification relating to his transaction with the cooperative society up to such monetary claim may be specified from time to time in such notification can be seen from subsection 2. It confers power of the state government to specify by notification in the official gazette the minimum qualification relating to the transaction of the member up to such monetary limit, and to say that member who do not fulfill such qualifications shall not be eligible for being eligible or elected as member of the committee or a society of which they are member. Lordship, here now I'll directly come to para 21. The next question for consideration is whether this is a pit case in which we should interfere. Now, normally, illegal acceptance of nomination paper do not constitute a substantial injury to the other eligible candidate. It is well settled principle in law governing resolution of election dispute that in case of illegal acceptance of nomination, the election of the candidate can be set aside only if it is proved by evidence that the result was materially affected on account of illegal acceptance of one or nomination paper. Therefore, in such cases, it is impossible to hold in a writ petition that the result of the election is going to be materially affected. Therefore, if the total number of eligible candidates whose nomination are accepted is more than the number of the candidates to be elected, even if a few nomination ineligible candidates are accepted, it would give no valid ground for interference in the writ petition. Logic. If the question is to be whether a candidate whose nomination is accepted ineligible, already accepted my nomination, logic, in this case, or not, is a disputed question of fact. This court decide that said question in the writ petition.
That is the clinching word, disputed question of fact.
Lordship.
So now according to you, you have paid.
Lordship.
According to them, they said that no, you have paid with a delay. Nomination paper was filed on a certain date, and your claim is that your payment was on 11/11 or something like that.
11/11/25, Lordship.
11/11, but the receipt was issued subsequently.
Not that.
So these questions, can a writ court go into all that and say no, you should have accepted, because he declares by an affidavit saying that on 11/11 he has paid. Can I say that?
Lordship.
This problem will come.
Lordship.
And above all that, another issue is, as pointed out by your friends there, that election petition, this has to be taken care of by an election tribunal, which is yet to be constituted. So it is not that you are remediless. Once it is constituted, you will be looked into, and if something was found,
Lordship,
then
para 22, I want to make it clear. The fact and circumstances and the reason which place this case in the exceptional category are flagrant illegally committed by the first respondent in accepting the nomination of the respondent. This was about the acceptance, but my case is different. Mine is about rejection, Lordship. It's
no,
rejection.
correct. Acceptance of the nominees, and they were declared as elected as being uncontested. That was at the face of it, it was discernible. They were accepted in violation of so and so. In your case, non-acceptance of your receipt, which according to you is the reason behind for rejecting your nomination, this may amount to disputed
Lordship,
questions.
no speaking order. They have violated, and as per 12.6, speaking order must be there. No ground has been given. This is the reason that I am approaching before this court. Lordship, see the page 21 of my writ petition. Rule 12, Rule 11, notification of nomination. Election to the 7G Sagali Gram Panchayat from the general constituency, so and so. Notice is hereby given time that the following nomination is in respect of the above election have been received up to 3 p.m. today. See, page 21, my writ petition. So my name is here in serial number 4, Lordship. See, I'm in serial number 4, page 21, Lordship. My petition, serial number 4, and I'm I have, after receiving all my necessary document only, they have accepted my nomination and this was notified. And this was, Lordship, this was notified on 24 itself. The page 24, Lordship. Down below.
Page 21, you are at serial number?
Serial number 4, Lordship. Serial number 9. Serial number 9. Page 21, serial number 9. And this is Lordship rule, see rule 11, notice of the nomination paper. That means already my nomination was accepted. And after preliminary check only they take the details of my NOC and all, they accept this paper. And it was notified by the RO concerned on 24/11/25, Lordship. Page 24 down below, that is mentioned here. Place Sagali, that 24/11/25 issued by, that is returning officer, 7 Sagali, ZPM constituency or Arunachal Pradesh, Lordship. So thereafter everything, and most interesting is they have not reject my on ground any speaking order. This is the reason. Deliberately, Lordship, this comes under rarest of the rare case, Lordship. So this court has to intervene. Otherwise, if I wait for this, the post-election decision, it will curtail my fundamental rights, Lordship. Lordship, totally, the people will be lost path on this Arunachal Pradesh Panchayat Raj Act 1997, Lordship.
No, the thing is that you see, your inclusion will means exit of somebody else, isn't it?
No, Lordship.
If you're included, somebody will have to be exit. Somebody will have to exit.
Lordship.
Page 27 in extra 5.
Annex Lordship. And this is after the submission nomination paper on 24.
Serial number 3 is the 711-2 of Upper Gal.
Lordship. And she is my opposite candidate. On 26, on the same day, the RO has published this notice, Form A, C Rule 13, list of validly nominated candidates. And this Form 11, Rule 11, that is the notice of nomination. That is notice of nomination that my nomination already accepted they have. So, Lordship, this is unfair, Lordship. So, interference under 226 of writ of Constitution of India is very necessary at this stage, Lordship. Otherwise, my fundamental rights, Article 14 and 21 will curtail, Lordship. So this court has ample power, an inherent power, and to make the system in a proper form. When it finds some wrong things in by the court below, either the government organ, then this court has the right forum to intervene and give justice to the petitioner or the angry person, Lordship. Moreover, Lordship, I have another judgment also. This is about the Lordship. Article 226 and 329B, writ petition questionable election bar under Article 229 when pool or re-pool process. This is about the pre and re-pool. When this court has the power to intervene under 226, Lordship. This is totally described. This is
but this is not in your favor.
Yes, this is about pre-election, but more particularly, my case is very unique and it is very different from other, Lordship. In this case, see, they have given me NOC. Government has given me NOC that you have paid already. That was accepted on 11/11/25, and thereafter I filed nomination. No any ground is there to reject me, Lordship, and they have accepted my nomination on 24/11/25, Lordship. And thereafter, without any reason, at least speaking order must be, Lordship, there by complying the Rule 12, Sub-Rule 6 of the Election Conduct Rule 2021. Lordship. That was, Lordship, violated, Lordship.
You have to wait for the tribunal. I don't think we can entertain it like this.
Lordship, then my representation may be directed to dispose. At
No,
least
but
speaking
again,
order,
presentation
speaking order.
also- How?
Today is Lordship, today is 5th. 10 more days is there. So 10 more days we can go to America and come back, Lordship.
Lordship, law is very clear, Your
No, no.
Lordship.
There is
Any
any
dispute regarding election has to be remedy lies before the election tribunal, not before the writ court. And Your Lordship, I would like to place one judgment wherein it clarifies that Article 243(0)(b) of Constitution places bar on High Court regarding rejections of nomination paper by the RO, Your Lordship. In citations. That is Karmabir, Tulshiram, Otade and others versus State Election Commission and others. Full bench of Bombay High Court, Your Lordship. Your Lordship, I would like to rely para 53, Your Lordship. Para 53. Here, the petitioner has challenged rejection of his nomination paper in this case, Your Lordship. May I, Your Lordship?
Yes.
Para 53. The common trait that emerges from a reading of decisions in NP Ponuswamy Supra, Mohindra Singh Gill Supra, and Ashok Kumar Supra is that in respect of challenge laid to the electoral process or any step connected therewith, before the result of elections covered by Part 15 of the Constitution is declared, the door of writ jurisdictions of a High Court would stand closed if any order were sought and rendered which has the tendency of effect of interrupting or posting a reasonable imminent poll. This is amply clear from the understanding of decisions of high authority as follows. Article 226 of the Constitutions pushed out by Article 329(b) as held at NP Ponuswamy Supra. The jurisdictions of the High Court under Article 226 of the Constitution suffer an eclipse because of Article 329(b) as held in Mohindra Singh Gill Supra. If the petition presented to the courts calls in questions and elections, the bar of Article 329(b) is attracted, else it is not, as held in Ashok Kumar Supra. Next para, 54. In all the aforesaid decisions, provisions of Part 15 of the Constitution together with the provisions of Representations of People Act 1951 were under considerations. The law laid down there admits of no doubt that the petitions under Article 226 of the Constitutions would not be maintainable if it calls in questions a step in election, and such questioning before the court may have the effect of interrupting, obstructing, or protracting the elections. Now, next para, Your Lordship, 50, 54, now 68, para 68, Your Lordship. Para 68. Relevant para. 68. For the reasons aforesaid, while agreeing with the view of Binod Pandurang Barsakde Supra, we answer the fundamental questions as formulated in paragraph number 27 in the negative. As a sequel thereto, we answer the questions referred by the division bench in the manner as follows. Allowing a challenge in the writ petition to rejections of nomination form to contest an elections and granting the relief claimed by setting aside such order of rejection is definitely not a step to subserve the progress of elections or facilitate its completions in the sense enunciated in Mohindra Singh Gill Supra and explained in Ashok Kumar Supra, though it may not always amount to intervention, obstructions, or protraction of the elections. Clause 2. Article 243(0)(b) of the Constitution of India is a bar for entertaining a writ petition under Article 226 of the Constitution against an order passed by the returning officer rejecting nomination paper, and such provisions would clearly be attracted whenever a writ petition is presented before a court for its considerations. Clause 3. The law laid down in Binod Pandurang Barsakde Supra represents the correct view of law. Consequently, we hold that the decisions in Srimati Maya Raju Gabgahave Supra and Sudhakar, son of Vittal Supra do not lay down the correct law. And in Pandurang also, Your Lordship, any disputes regarding elections can only be raised after elections are over, Your Lordship.
Lordship, at least for the interest of justice, at least my representation may be.
For the school reports with the data. Then on the facts also, there's a dispute regarding the rating of the everyone. That report, that you take. Wait, you're not remedy less, you have to wait for something.
Arnabam.
Ranju?
Answers of the 3 questions. Relating to the actually for that release for the next doctor. On the other hand, there's practice upon the by citing. The third party, other item. Till Ramakrishna Park, that is presiding officer and assistant registrar of property site. Bangalore. 1991. 0 Supreme bracket KAR 485. Present at the appropriate date. Also, Dash 4 brackets small v of the Constitution here. Provides for a bar for the meeting and its under Article 6 of the Constitution against the order passed by the returning officer rejecting the nomination paper and such provisions be attractive whenever a petition is submitted for the board for its consideration. Considering the above conditions for it's it's a repetition with regard to the remarks protected not be entertained by so we will be however open for the listener to afford the review as we have seen this also.
Obliged. Close. Obliged.
Item number 5.
My lord, this is in fact a very long pending matter. Matter was in fact heard on last occasion. This honorable court felt that 2 new respondents be impleaded. Now they have been impleaded now. My lord, I pray that this matter will be listed after a week. I have just got a document. Maybe this has become infructuous now. It was regarding a promotion. Now it appears the petitioner has been given seniority. So yes, I just had text him and he has sent me an order. Provisional seniority list was issued. Where is he has been placed? Yes, sir.
And Padam. Tourism Department, Standing Council, Tourism Department.
Well, obliged.
Item number 6.
Please, my lord, I appear for the petition.
Next.
I appear, my lord, for the petitioner. Your lordship issued notice on the last occasion. Counter affidavit has come. Rejoinder has been filed and we are ready to argue today. If your lordship will kindly turn to the petition. Page 6.
As per the information, my lord, the instruction received from the authorities, my lord, basically it has been done by the, my lord, the state government, my lord. Basing on the, my lord, the information received from the state government, today, my lord. Yes, my lord, there is no issue, my lord, from my side.
Yes, my lord, I have also no issue, but however, my lord, respondent number 1 yet to appear, my lord. Respondent number 1, my lord. Respondent number 1 is Delhi Police, my lord.
In this matter, Your Honor, we have filed, the service has been complete, Your Lordship. We have filed the additional affidavit as well, Your Lordships.
Yeah, Delhi police has been served.
Has been served, duly served. We have filed the report of service also.
And we are ready, my lord, to proceed today. We are asking, my lord, for the setting aside of the lookout circulars, so that she can go abroad to Dublin once again.
Circulars have been issued by whom?
By Bureau of Immigration, my lord, under MHA, my lord. On the basis of the, my lord, respondent number 1, 2, my lord, 2, yes.
You are presently respondent.
2 and 3, my lord. No, my lord. But as per the instruction, my lord, received from the, basically, they executed the instruction received from the, my lord, the state government, my lord. Other respondent number 4, my lord. My lord, then
Yes, I'm for the respondent number 4, my lord. SPP, SIT, my lord.
no case is, my lord, pending against this respondent number, my lord, before the respondent number 2 and 3, my lord. But they executed the, my lord, the LOC, lookout notice, my lord, NOC, my lord. That was done.
Who has issued the lookout notice?
No, of course, my lord, the respondent number 2 and 3, my lord, but then on instruction from the, my lord.
On the instruction of respondent number 4.
Correct.
Yes, my lord.
Why have you instructed?
My lord, as because, my lord, the respondent, this petitioner, my lord, petitioner, he was already served a notice to appear for the investigation officer, my lord. But without informing the investigation officer, on the 1st of September, she was served a notice to appear on, my lord, on 4th of September. Yes, my lord. Yes, my lord. That's fine, my lord. Yes, my lord. Yes, my lord.
So, my
Yes,
lord,
my lord. We have filed, my lord.
the reply be
Yes, my
filed,
lord. That is our stand.
and we are ready to start, sir. We have got their affidavit and we have filed
You
our
have filed a
reply.
reply also.
Yes, it's filed.
LOC, okay, LOC.
We are ready to start.
Sorry, I pulled it off. You are ready to file, you have filed your affidavit of opposition
Yes, my lord. We have filed.
and the petitioner has filed a reply also.
Yes, my
Yeah.
lord.
Correct?
Yes.
And Mr. Kato, you have not filed anything, isn't it?
No, my lord.
Only your version is that you have been instructed by the respondent number 4. That's why he had issued that.
Yes, my lord.
Please, my lord. May I begin, my lord?
Any difficulty?
I'll
No
go
difficulty, my lord. Since respondent number 1 is yet to appear, that is,
But one is served already, then what to do? Why is respondent number 1 important?
One is hardly
Why do you
important.
require?
One is the person who
he
stopped
is the
it.
one who executed
Yes,
the
hardly
order issued by the respondent number 2 and 3.
we have served them.
They have only executed, they'll come and say that we have executed because 2 and 3 had instructed us.
Yes, my
And
lord.
when we asked 2 and 3, they said we have been instructed by 4.
My lord.
So that's how it all.
May I pray this, my lord? One more opportunity may be given to my lord, the correct position of the, my lord, the issue from the respondent number 2 and 3, my lord. Matter may be fixed on, my lord, 10, and on which date, my lord, the disposal will be made, my lord.
No, correct position means what?
We'd like to start
Yes, my
with
lord.
this. She'll get a chance to go to Dublin again. There's a second round. I don't want to be detained here. They have caused me such a loss, my lord. Air ticket, new air ticket,
On date, my
everything.
lord.
When is the second chance?
Now starting right
Happening?
away. Right away, my lord. We have to argue, my lord, now.
No,
They've
no.
done-
The petitioner wants to go to Dublin.
Go back again.
And when
They
is, when,
every-
That is expired, my lord. Now,
3 months
whether-
already
the
expired.
question is, my lord, that lookout notice is still survive or not, my lord? On which date, my lord, she proposed to go abroad, that is already expired, my lord. And if another chance she want to take, the question is again, my lord, that lookout notice is still survive or not?
And the
That
whole
lookout
issue
notice
is,
was-
my lord, were they right in doing what they did? They relied on certain FIRs. They maintained their position even today that they correctly did what they did. Therefore, they can do it anytime. There's no problem unless your lordships interfere. They will do it anytime. And it's a very high-handed action that they took. That's why I want to argue, my lord, have the whole action by the state quashed, their reasoning set aside, so that, my lord, we are free to go. They say they were absolutely right in stopping her.
My lord, may kindly peruse the, my lord, the affidavit filed by the other respondents, page number, my lord, 7,
Sir, I'll start with the case.
147. my lord. Type copy is
There's no point
147.
starting in the middle by some reply. I'll start with the case, my lord. Kindly turn
No,
to page
just a,
6 of my petition.
no, just a minute, Mr. Counsel.
Yes, Lord.
Mr. Kato,
Yes.
why do you want me to see those documents? What is that?
This is the my lord, the lookout
circular.
circular.
Page,
issued by the-
page?
page number my lord, 147 of the affidavit filed by the respondent number 4.
No, there is no 147. There's a separate file.
136.
The affidavit filed by the respondent.
No, there's a separate file, that's why.
My lord, it continues from the petitioner petition. Then after, if any affidavit other than my lord,
Hmm. Yes, 147 what?
yes, my lord, this is the type copy, my lord. Subject opening of regular LOC, New Delhi. So
No. I don't think that's what we are looking at. We're looking at different pages. 147 is different. This is a part of the counter affidavit.
my lord, affidavit filed by the respondent number 4, I am perusing, my lord. Lookout circular issued by the ministry.
Okay, which page?
147 of my affidavit of position filed by the respondent number 4, my lord.
147 comprises of paragraph G, H, I, J. Are you reading something else? Your 147, my 147 are different, it seems.
My lord, if I may,
No, you just describe what is the thing that you are trying to read. It's an annexure.
Annexure, my lord.
Annexure 1, 2, 3, which one?
Annexure, my lord.
One,
my
annexure
lord.
one.
Type copy is
Annexure
annexure. Next page.
Yes,
Annexure.
yes, this is 153 in my copy.
I'm sorry, my lord.
Which one?
In fact, my lord.
So this
Annexure-
confusion is happening, not only this case, in other cases also. The continuity of pagination, somehow it doesn't remain the same for the parties concerned.
Some
Court has a different pagination, you have a different pagination,
Correct.
respondent will have a different pagination.
I'm sorry, my lord. This is the affidavit filed by the other respondent. So, my lord, some accommodation may be made. My lord, will clarify and we'll go through the, my lord, the files and all.
No, my
So
lord,
that, my lord,
I'm objecting. I want to continue.
No, that's not the way, Mr. Kato. You want to clarify what? You have not even filed an affidavit. What do you want to clarify?
my lord,
You have to make a reasonable submission.
my lord, no, lookout notice, lookout circular issued by the ministry on receipt of the direction from the state government, respondent number 4. That lookout notice, I just wanted to show your.
Show me now. This is the page. What do you want me to see in this page?
Yes, ma'am. Annexure 1.
Yes. What is there in Annexure 1? Tell me.
My lord, may I read, my lord?
You don't have to read. You consume time. You just point out the difficulty. Which paragraph? Or you simply say that you're not prepared. That's all.
Yes, ma'am.
Oh, yes.
So, my lord,
I have to
therefore,
prompt you for that.
the originator.
I don't think we'll adjourn like that, Mr.
No,
Kato.
no, my lord.
I don't
I'm
think.
not for, my lord, on that. my
Mr.
lord.
Kato, you have to make a reasonable prayer. You see,
I
at the
don't-
outset, you should say, I need to go through the thing and prepare and make my submission. You have not said that. Simply by taking me to one annexure and for whatever purpose, I don't know, you're not even able to explain. Why should we
My lord.
grant you time like that?
My lord, I'm in fact not for the, my lord, the accommodation, my lord, in fact.
Then,
My lord, my lord,
then you will make your submission when your turn comes.
yes, ma'am.
Yes,
Correct.
Lord.
Yes, ma'am.
Yes.
Yes.
Kindly, my
Please
lord,
start.
the petition. Yes, please. And go to page 6 of the petition.
Page 6.
Yes, Lord. And in paragraph 3, my lord, of page 6, I say, I was to go to Dublin City University from September 8th to 28th November 2025. That is why I booked my ticket and I went to the airport to go to the university. So the first condition for an LOC is that I'm evading arrest does not arise. It was a routine assignment to me. I was to go to Dublin University for 3 months and I booked my ticket. I went to the airport. Now, my lord, kindly turn to page 7.
Mhm.
The LOC was never given to me. I was never informed. They just sprung a surprise at the airport and said, you go back. So my ticket I lost, my training I lost, and now I have to get a fresh ticket and spend more money. Now, my lord, look at the bottom of page 7 is the first FIR on which they rely, 28/5/25. And if your lordship scans that FIR, your lordship will see that there is nothing here which is against me at all. I'm not even mentioned here. That's the first FIR. Now, my lord, look at the second FIR at page 8, bottom of the page. This I will read to your lordship because I mentioned here. Turn the page, my lord, to page 9. The officer in charge, Bolang, etc. Initially, the SIFF, that is, my lord, the organization to which I belong, Siang Indigenous Farmers Forum. Yes, my lord. Invited me to a meeting on 25 May 25. I had assented to their request, agreed to meet them. As per the request, the DC Siang district had arranged the meeting. Accordingly, on 27 May 25, Siang in the SIFF, executive members and myself, etc., and government officials at the conference hall of DC office regarding the Siang Upper Multipurpose Project. I was assured by the executive members that the meeting would be peaceful, and accordingly I attended the meeting. The meeting concluded on a very positive note. That is very important because I'm only concerned with the meeting, not about what happens outside the meeting after the meeting is over. So I did a meeting, I invited them. The meeting concluded on a very positive note at 5 p.m. And everything against me is after 5 p.m. I'm not responsible, my lord, for that. However, during the course of the meeting, unaware to us, a mob of 100-200 persons, disorderly and potentially violent, had gathered around outside the conference hall, etc. Sensing the gravity and severity of the situation, my security person advised me to stay in the DC chamber until the situation normalizes. However, after waiting for 1 hour in the DC office chamber, and also as I had to proceed to Tezu Lohit district, I was advised to leave the office premises. As such, I was escorted out by security personnel. The entrance gate of the DC office was blocked by the mob. The mob was very aggressive and they kept pushing me, and the security person prevented us from leaving the DC premises. However, with the help of a security person, I managed to get away from the mob and was escorted towards the DC's residential quarter. When the mob was preventing me from leaving the office premises, a man in green coat threw chili powder at me. That's the first thing, my lord. I'm not concerned with this man. When I was being escorted toward the DC, an unknown lady tried to attack me. I'm not concerned with that lady, my lord, which was disarmed. On top of that, as I was leaving the gate, an unknown person in yellow t-shirt tried to land a blow at me, which was duly prevented. Lastly, as I was proceeding towards the DC residence, a person among the mob threw stones at me, trying to cause harm to me. Unfortunately, it landed on one of my personal staff, causing grievous injury on his head. The videos of the incident is the next here under. That's very important. These videos are very important because I am still in the DC office. The DC is trying to go. I cannot leave because there are people there. I am still in the DC office and certain people try to throw chili powder and so on.
Who has filed this FIR?
This
The
is my lord.
minister.
FIR,
The
Officer,
minister.
FIR filed by
Ojing Tasing, the minister.
minister.
yes. Now, my lord, the video of the incident is annexed herewith. And I have specifically said, if you see these videos, I do not figure in these videos at all. I hold a meeting which you yourself say ended on a very positive note. That it has come to my knowledge that while I was attending the meeting, the mob was gathering, instigated and incited by the following persons. And there, my lord, my name figures T, Advocate Banu Tatak. The above named persons incited and instigated the mob against me. All the videos can be seen. There is no role of myself in the videos, and I was not outside the DC office at any time. I stayed inside, even after the DC. They also spread a wrong narrative that the SIPF legal advisor, Ivo Milli, has been detained by the police and kept in unknown location at my behest. They had malicious intent to hurt me and cause bodily harm. I would have lost my life if I had not been protected by my PS and police personnel. The above named persons have malicious intent against me, would desire my death by any means. As such, I have an apprehension that they would try all means to kill me, etc. In view of the above, you're requested to investigate and book the aforesaid persons for mob lynching, attempt to murder, instigating and inciting mob. Now, my lord, paragraph 9, I was inside the DC office as part of the negotiating team. Then the officials were escorted out of the room. The petitioner and her group remained inside. Now, my lord, in their reply, there's no denial that I remained inside the room where the meeting had ended on a very positive. There was commotion outside, but no violence and no attacks and no injuries. And the multiple videos, my lord, are at page 45. There are about 10 or 11, 12 videos at page 45. I've given the link. Anyone can open that link and look at the videos. And my lord, I am not concerned. Now, my lord, kindly turn to page 12, para 11. Because I'm asking for the setting aside of all the lookout circulars. And the Supreme Court said, my lord, in Delhi, the Delhi High Court said, page 12, para 11, in Sumer Singh's case, there are three conditions for the issuing of a lookout circular. Sumer Singh, my lord, middle of the page. Recourse to LOC can be taken by investigating agency in cognizable offences. So against me so far, no cognizable offence. Where the accused was deliberately evading arrest will not apply in my case. They summoned me, I went. They summoned me a second time, third time. I'll tell you, Lordship, what happened. Deliberately evading arrest, not appearing in the trial court despite NBWs, no NBW issued in my case, and other coercive measure, the likelihood of the accused leaving the country to evade trial and arrest. This is, my lord, the law on LOC. There's not a in the facts of my case. Now, my lord, paragraph 12, the videos in connection with the 2FL show no cognizable offence. I'm not evading arrest. No non-bailable warrant has been issued, and there is not even a remote likelihood of the accused leaving the country to evade arrest. I was leaving the country for a 3-month course, not to evade arrest. Now, my lord, just see paragraph 13. See my cooperation. So I get my first summons, my lord. And I was called on the 30th of August. I immediately went to the crime branch at Itanagar. I traveled, my lord, from the Siang Valley. I go some 8 or 9 hours, travel to Itanagar and give my statement verbally, which was recorded by the SIT inspector SIT inspector, and was with the said officer for 2 hours while he typed on his computer, etc. Now, this paragraph 13 is very important because in the counter affidavit filed by the government, paragraph 13 is not denied. So I go, my lord, 2 hours he sits on the computer and records my statement. And this paragraph 13 is not denied.
Okay, then next.
Yes, my lord. Now paragraph
Second
14.
call.
Yes, my lord. Yes, yes. Now, my lord, I go on the 30th. Then I travel all the way back to my house. I travel 9-10 hours. And my lord, when I go there, I go for some work and so on. When I reach my house, a second notice has already reached and my brother has that notice. On 3/9/25, a letter was delivered to my house in district so-and-so, and I was asked to report to the SIT branch at Itanagar. Barely have I gone back after a 2-hour deposition, then I come to my house and I get a notice, you come back to Itanagar. No problem,
No,
sir.
that was on 30. That was on 30th August 2025.
Yes, my
when you had cooperated and you had been giving statements for 2 hours.
Yes, my lord.
Correct.
And I
And
go
the
back.
other notice came only a month after that.
Yes, my lord.
3/9.
I'm dealing with that. Yes, my lord. Not,
So how do you say that you barely reached home and again you have to go back?
Yes, well, and I've described that in detail in my rejoinder. So I'm just reading it briefly here. But in my rejoinder, I'll tell you, Lordship, exactly what trouble they put me to. And then, my lord, the third summons, which I go and again 3 hours. 3 hours deposition over a matter like this. Second, I missed, my lord, I'll tell you, Lordship, why briefly, but I'll read it out from my rejoinder. I had my ticket booked to Delhi. I had to go to Delhi. I was to stay with my sister for 1 day and then catch the flight and go to Dublin. And now it's not possible. You tell me, come back,
4/9.
etc., etc. But I'll read it fully.
On 4/9.
Yes.
4/9, correct? You had a
Yes.
ticket on 4/9.
Yes, yes, my lord. I'll read it from my rejoinder if you don't mind, my lord. Let me just finish this right now. Now, my lord, paragraph 15. Petitioner was unable to report because she had already booked a ticket on 4/9. The time to reach Itanagar would be approximately 8 hours. It was dangerous for her to travel at night. Impossible to go to Itanagar as requested by the police. There was no evasion at all. However, the petitioner had submitted a comprehensive statement, which etc., etc. Now, my
That
lord,
was
look at
on
the anticipatory.
30th August.
Yes, now, my lord, look at Paris 16. This is very important because the court is granting me anticipatory bail and the observations are very important. Now,
This is what anticipatory bail applied at which stage? At what point of time?
सर मेरा ये चल रहा है हाई कोर्ट हियरिंग चल रहा है वर्चुअल हियरिंग वीसी अभी थोड़ा देर में खत्म हो जाएगा आपको हम कॉल बैक करेंगे
May I read this, my lord, paragraph 16? This is the
Yes,
order of
you read, but I'm asking you, this anticipatory bail was applied at what stage?
anticipatory bail. It was applied when we first got the FIR knowledge of the FIR, Your Lordship. So this was before issuing of any summons.
See, madam, I think I would like to hear only one counsel for a party.
Yes, my lord. It was done, my lord. I'm so sorry, my lord. It was done, my lord, when we came to know that these 2 FIRs are registered. And we apprehended that is possible.
So
that
either you submit or the senior counsel submit. One of you submit.
Yes, my lord. I'm so sorry, my lord.
Unless some clarification is required, please don't interrupt. Yes.
Yes. So,
Please
my lord,
continue.
my lord, can I read the anticipatory bail order? If your lordship permits. It's very important.
Yes, you may read.
Yes, my lord. None of the witnesses have stated anything against the accused. Admittedly, the mob gathered in the office premises and commotion took place in which the complainant and others were manhandled. However, there is no material to relate the incident or the people present there with the accused. In fact, till now, the IO has not been able to identify a single person, despite the claim of the police of having videographic and photographic evidence. The IO has also written to this court raising objection against bail. Such objection was raised to the PP on the ground that several witnesses are yet to be examined. In para 7 of his written objection, he has stated there was also a deliberate spread of misinformation by the accused, including false claims that the SIF legal advisor, Advocate Ibo Mili, was unlawfully detained on the direction of source. These actions appear to have been intentional and aimed at inciting public interest, ultimately culminating in a violent confrontation. So this is an inverted commas. This is the stand of the prosecution. The incident took place on 25/5. FIR was registered on 11/6. There are allegations of throwing of chili powder, attempted attack with knife and punch, throwing of stone leading to grievous injury. Also, the IO has claimed videographic and photographic evidence to substantiate carrying of local so-and-so by the mob. Interestingly, even after a lapse of 1 month of lodging the FIR, not a single person has been identified. Also, the person who allegedly received serious injuries has not been examined till date, raises doubt about the incident of throwing stones. Further, there is not a single evidence to show that the accused had a direct role in instigating the mob. Even if it is presumed for the moment that the accused instigated the mob and took active participation, the offense is bailable. The only non-bailable section is 109, which is attempt to murder. If at all there is any incident relatable to attempt to murder, it is the accusation that a woman tried to attack the complainant with a knife. Here also, despite having videograph and photographs of the incident claimed by the police, and also the fact that security personnel prevented the said lady, there is no material to substantiate the existence of the fact that the woman actually attempted to attack the complainant with a knife. Therefore, I do not find element of anticipated murder in the entire incident. There is no prima facie case of anticipated murder. There is only non-bailable offense. In view of the above, the interim order dated 4/7/25 is made absolute. Now, my lord, kindly
Okay.
to page 16. Now, my lord, kindly go to page 17. Paragraph 18, 19 are paragraphs relating to the Supreme Court judgments and the, Supreme Court judgments relating to the right to travel abroad. I won't read this, my lord. 18 and 19. That is Priya Pillai and Satwan Singh. They both say that the right to travel abroad is a fundamental right under Article 20. Then, my lord, straight away go to the prayer clause at page 26.
Yes.
Issue an appropriate writ, order, or direction in the nature of certiorari quashing all lookout circulars issued against the petitioner as being arbitrary, illegal, ultra vires. Prayer clause B. Issue a writ directing respondent number 1, 2, and 3 and all immigration authorities to permit the petitioner to travel abroad to attend her 3-month course program. C. Restraining respondents 3 and 4 from issuing any further lookout circular against the petitioner in relation to the said 2 FIRs without prior leave of this court. And D, my lord, for payment of compensation. And my lord, at annexure P1, page 31, your lordship will see my invitation by the Dublin University.
Yes.
Then, my lord, At page 46 is Sumer Singh's case, the Delhi High Court judgment in Sumer Singh's case. And my lord, the most important part of the judgment, my lord, is important part is, my lord, if your lordship comes to 54.
Yes. 54.
Yes, Lord, 54. Paragraph 9, it is clear in paragraph number, my lord, 9. Page, my lord, 54. It is further clear, lordship has that in terms of a
Yes, yes.
there is a specific format in which a request must be made for the opening of the LOC, and it should be issued with the approval of an officer not below the rank of Deputy Secretary. Now, my lord, could look at the paragraph below that. That is, my lord, internal para 16, just about 20 lines from the bottom of the page. There are powers that are required under the law to be exercised with caution. That's the important thing. You can't mechanically do this, to be exercised with caution. And my lord, a little lower than that, where they quote from Maneka Gandhi, there has to be application of mind by the authority to the relevant factors. Now, my lord, kindly turn to page 57, where the condition for issuing the LOC is given.
Yes.
Second last paragraph of that page, my lord. Recourse to LOC can be taken by investigating agency in cognizable offences. 1. Under IPC or other penal laws where the accused was deliberately evading request. Second condition, not appearing in the trial court despite NBW's. Fourth condition, and other coercive measures, there was likelihood of the accused leaving the country to evade trial and arrest. Not one of these conditions are satisfied in the facts of this case. Now, my lord, the other decision I rely on, my lord, is kindly go to page 66, my lord, and next year P9. 66.
Yes, which paragraph?
Yes, paragraph 1, my lord, because this is Priya Pillai who was going to go abroad to the UN to give a little talk about human rights in India. And my lord, very similar, not very similar, but somewhat similar. But I want to read paragraph 1. Every once in a while, citizens going about their usual and ordinary business get entangled with the state apparatus, sometimes for good reasons and at times unjustifiably so. In such a situation, an aggrieved citizen's remedy, quite naturally, is to approach the courts of law for appropriate relief. These remedies at most times are financially debilitating and not within the means of every aggrieved party. 1.1, the petitioner chose to travel to the UK, etc. in the early hours. She was, however, stopped for reasons that I shall shortly advert in the course of my discussion. And my lord, the reasons as spelled out by the court show that she was never informed and she was simply told, you have to get off, you can't proceed with it. Now, my lord, the important parts of this case is, my lord, para 71. Yes, Lord.
All right, we resume at 2.
Yes, Lord, grateful.
Lordship, I truly apologize because in morning time, in mention hour, I was supposed to mention one item, but I was having one judgment in court 5 in double bench. So I have to attend that judgment. So when I came back, it was over. So kindly, if you permit, I'll mention the item number 19.
19.
Yes.
Yes, what do you want?
My senior counsel, Mukherjee sir, he's out of station, Lordship.
When?
So,
When do you want it?
any 3 weeks, 2 weeks.
As paid for on behalf of Mr. M. Patil, Learned Senior Counsel for the petitioner. List again after 3 weeks.
Hello, please.
RVC matter, item number 1, BA 54 of 25.
May I please, Your Lordship?
Just a minute, Mr. Gonsalves.
Yes, my lord.
We have one fixed matter at 2 through VC. So I'll just attend to this, then we'll come back to your case.
Please, my lord.
Okay. Yes.
Yes, my lord, this is bail application filed under section 483 BNSS, read with section 37 of the NDNPS Act.
Okay.
That, my lord, the applicant was arrested on 4/7/2023 at 10:30 p.m. for alleged involvement in connection with seizure of 4,378 grams of suspected methamphetamine at Trumpui, Aizawl, and was charged under section 22C of the NDNPS Act. That, my lord, there are gross violations of Article 22(1) of the Indian Constitution and the mandatory provisions of Section 42 of NDNPS Act and Section 52A, and as well as the NDNPS rules of 2022. Also, my lord, one of the other grounds is that he has some medical problems as well, which needs treatment from outside the jail.
Why is it listed before this court?
My lord, your lordship had already disposed. This is the second time that we are approaching this honorable court.
This is the second bail application.
Yes, my lord.
Earlier bail was rejected.
Yes, my lord. My lord, it's at page.
So what new grounds do you have now?
The new grounds is Article 22(1). And also, my lord, Section 42 has already been disposed. However, there are some new developments with regard to that.
What is that?
The witness, the prosecution witness, Mr. Dhyan Singh, has deposed before the court. And in his deposition, he had stated that there are like violations of Section 42.
Where is that?
Yes, circumstances.
Where is the deposition?
Yes, my
Where is the
lord.
deposition? Have you annexed it?
Yes, my lord.
Where is it? Page number?
Index.
At any rate, today is the first day, isn't it?
Yes, my lord.
We'll issue notice. Mr. Johnny is there?
Lordship, yes. I'll accept notice
For
on
which
behalf of the
respondent?
respondent. Your Lordship, yes.
Huh? For all respondents?
Yes, Your Lordship.
Okay, please write. Hart, Miss Lalngai Saki, Fanai. Learned counsel for the applicant through RVC, who submits that this is the second time the applicant has filed the bail application. Stop. She submits that earlier bail application, being bail application number 8 of 2025, was rejected by this court. White order dated 8/5/2025. Stop. Since there are new grounds to be taken in the instant bail application. The same has been filed once again before this court. Next para. She submits that the applicant was arrested on 4/7/2023 in connection with seizure of 4,378 grams of suspected methamphetamine at Hotel Sangtea, Chuampui, Aizawl. Stop. Accordingly, customs case number 1/CL/NDPS/AS/AZL/23 dated 4/7/2023 under section 22(C)/23(C) of the NDNPS Act was registered and investigated into. Snap. Upon conclusion of the investigation, charge sheet was submitted on 3/11/2023. 3/11/2023. With a finding that there was a prima facie case established against the applicant.
Also, my lord, if I may make one submission,
Yes.
the
What is that?
co-accused, David Lala, was released on the same ground in violation of Article 22(1) of the Constitution of India. My lord, the bail order is at annexure number 7 at page 149.
He's right. The Learned Counsel submits that there is violation of Article 22(1) of the Constitution of India, and for which reason the applicant has sought for the instant bail, amongst others. She submits that, in fact, a co-accused person has already been released on bail, right order dated 13/11/2025, in bail application number 42 of 2025. She therefore submits that a similar benefit should be granted to the instant applicant as well. Next para, in view of above, issue notice returnable by Mr. Johnny. Well, can you be ready?
Lordship, next week, Tuesday, if possible, Lordship.
Let us have it on Wednesday.
Lordship, yes, no problem.
17th? 17th?
Yes, my lord.
In view of above, let's again issue notice
Not
returnable
17th,
by
my lord.
17th.
17 is vacation, already vacation.
10, Lordship.
10th. My lord, today is 5th.
Oh, I'm sorry. Yes, 10th. It's not vacation here, actually. It's vacation there. In view of above, issue notice returnable by 10th of December. Mr. Johnny L. Tochong, Lanet Special Public Prosecutor, Customs. Access notice on behalf of all the respondents, and therefore no formal notice is required. Petitioner, applicant shall, however, furnish requisite copies of the bail application to him if not already done. List accordingly.
Really oblige.
All right.
Item number 6, WP Criminal 3 of 25.
Yes.
Please, my lord. We were reading, my lord, at Priya Pillai's case at page 72. The paragraph right at the beginning, the right to travel abroad is a fundamental. So that's all, brother. That's the proposition.
Okay.
So if you breach a fundamental right and the state prevents a person, there must be really serious reasons for doing it. Can't be done casually.
You were
Namalot-
saying that the such kind of lookout order or such kind of orders can be passed only by person with responsibility. Like you had mentioned about Deputy Secretary, Government of India.
Yes, sir.
Powers under this it can be exercised only with caution. Now,
Yes.
in your case, who
Yes.
would be the authority empowered to issue such kind of prevention?
If the judgment is to be followed, my lord, the Deputy Secretary of the government. But I think this is done by the Superintendent of Police.
Okay.
So they may need to clarify whether he had authority to do it at all.
Mm. What is the full form of LOC?
Yes, Lord, the
Lookout. Lookout.
circular, yes.
Lookout circular.
Lookout circular.
Circular.
Yes.
Lookout circular. Okay.
I'll come to that when I read their counter.
Okay.
I'll deal with that. Now, my lord, I just want to summarize what is there in the petition. The first is my name is not there in the first FIR. In the second FIR, it is not disputed that I remained inside the DC office and the commotion is taking outside. Third, my lord, my pleading in paragraph 9 that I remained inside even after the DC left in the reply is not controverted. So now the facts are undisputed that whatever commission took outside, I was not there. I and my negotiating team remained inside. Fourth, my lord, the anticipatory bail order which I showed your lordship, that has never been challenged. That has never been challenged, and the anticipatory bail order is a very strongly worded exoneration as far as I'm concerned. Prima facie, exoneration as far as I'm concerned, and never challenged. And the anticipatory bail order says there's no connection between me and all the accusations that are being made. Now, my lord, I go to the counter, and in the counter also, there is no attempt to show any connection between me and all these allegations about creating commotion and so on. So I turn now to the counter. I turn now to the counter, my lord, to show your lordship what their stand was and take you to the rejoinder. So in the counter also, there's no attempt being made to link me with any of these acts. Because they have to link me with the two FIRs. The lookout circulars because of these two FIRs. But if you can't link me with the FIRs, even in your reply, you don't make an attempt. Anticipatory bail says no connection. Now, even in your reply, you don't try to overcome that lacune or deficit in the pleader. Now, Manoj, kindly go to their counter.
Yes, page number.
Page number.
Counter of respondent number 4.
Yes, my lord. This is respondent number. This is the counter filed by, my lord, give me a second. Additional Secretary.
Additional Secretary.
Respondent number 4. Now, my lord, at page 135, I hope the numbering is correct. Internal page 2 at the bottom of the page.
135.
Yes, my lord, on my copy, I hope that's correct. Otherwise, my lord, internal page 2 of the affidavit, bottom of the page.
Whose affidavit are you
This
taking me to?
This is the affidavit of Shri Ashok Taeng, Inspector of Police Crime Branch.
But you just said Deputy Secretary, that's why I got confused.
No, my lord, that is the case law says that the LOC should be by a senior officer of the rank of
Correct. That is regarding that LOC.
Yes,
But the affidavit is filed by one Ashok Tayeng,
yes, my lord. Yes. Now, my lord,
Inspector of Police.
yes, my lord. Go to the second page of that affidavit, paragraph 5,
Yes.
bottom of the page.
Yes.
I'll read from the beginning that in regard to para 7, the answering deponent humbly states that though the petitioner is not a named accused in Bole PS number so-and-so, she is the legal advisor of Siang Indigenous Farmers Forum. She, along with members of SIFF, organized a set meeting wherein the alleged incident transpired. The meeting was attended by so-and-so. Last line, the involvement of the petitioner has been reflected in the statements of witnesses. They categorically stated that the petitioner disrupted the peaceful meeting by alleging unfounded allegations against the authorities, that the FIR had been registered against one Mr. Ibo Mili, and that authorities detained him at some undisclosed location. In response, the Deputy Commissioner and Superintendent of Police refuted the allegation. Despite the official clarification, the petitioner incited the mob, which ultimately led to violence. So this is their first statement. Now, my lord, go to para 10, please, my lord. Middle of that para. That in para 10, in regard to para 2, the answering deponent states that as per the second FIR, so-and-so, the petitioner is named accused and has committed cognizable offense. Moreover, during the midst of investigation, the petitioner has attempted to leave the country without informing the investigating agency, despite notice of 2/9/25 for her appearance. The petitioner has not been cooperating. So the second FIR, my lord, is in respect of, just to refresh your lordship's memory, is in respect of what happened outside. And I said I was inside, and para 9, I said I remained inside, and in your counter affidavit, you don't contradict that. So second FIR also, there's nothing really against me, but I'll deal with it properly. Then, my lord, para 11, the remaining part is that I deliberately evaded going for the second summons. First summons, lordship saw that I stayed behind. I gave a 2-hour statement, and then I left and I got a second summons almost a day or two later. Now, my lord, paragraph 11. In regard to para 13, the petitioner was issued a notice on 28/8/25 to appear before the police station on 30/8/25. This is the first summons at 11 hours. However, she appeared at 1800 hours, well beyond the given time. She was requested to come on the following day, but she insisted on accordingly examined in presence of so-and-so police officer of crime branch. So they said, come tomorrow. She said, no, take it today. After her examination, which was of 2 hours, your lordship will remember, the petitioner was issued another notice to ensure her presence on 2/9/25, 2 days later, to verify her deposition and for further investigation. However, the petitioner refused to accept the notice and categorically declined to cooperate. I don't agree with this, but that's their case. Then they sent it to me by post. That a GD entry has been made, etc., regarding her refusal. That in regard to paragraph 14, the answering deponent states that notice. So now they send me a notice. This is the second summons. Notice dated 1/9/25 was duly served to the petitioner, which was received by her elder brother on 2/9/25. So this is in my village now, far away. and not on, I said it, I got it on 3/9/25 because my cases, I was traveling on 2/9, I wasn't at home, I got it on 3/9. Nothing will turn on that. The petitioner is trying to mislead, etc., etc. Then, my lord, kindly go to paragraph page 140 or internal page 7.
Paragraph?
Top of the page, my lord. The
Which page?
petitioner, page 140 or internal page 7.
144.
140, page 140.
140.
Yes, my lord. Internal.
140, yes.
Yes. The petitioner has refused to receive a notice given to her by hand on 30th/8. On top, your lordship will have some provisions of the act. Then it says the fundamental rights under
Yes, yes.
Yeah. Then the next paragraph. Petitioner has refused to receive a notice given to her by hand on 30/8/25 for her appearance on 2/9/25. So when I give my 2-hour thing, I go away. They say we tried to give you a notice on that day, but you didn't take it. I deny that. Nothing may turn on this much. Later, she again deliberately refused to appear at crime branch on 4/9. So the second summons says, come on 4/9. Yes, my lord? And this was served on my elder brother, that is correct, on 2/9/25. He got it on 2/9, I got it on 3/9 because I was not at home. Instead, the petitioner trying to, this is the evasion point now, which will attract a lookout circular. If your lordship comes to the conclusion that I'm deliberately absent because I'm evading going in response to a summons, then, my lord, the case may go against him. Otherwise, not. Instead, the petitioner trying to evade the investigation process by traveling to Delhi on the same day of her appearance at the police station. The petitioner also attempting to travel abroad without informing the investigating agencies. This is non-cooperation. So my not turning up on the 4th of September deserves a lookout notice against you. That's basically what they're saying. Now, my lord, kindly go to page 143, para 10. Paragraph R. (143, para 10).
Yes.
143, internal page 10, para R. LOC can be issued against a person accused of a cognizable offense. So far, not accused of a cognizable offense. When they might try to avoid due process of law. So your lordship has to decide, I'm absent on that day, no doubt. Was I trying to evade the due process of law? And then the next paragraph, he says, they have registered the FIR, that is the day after R. The whole so-and-so was registered owing to an assault on a sitting state cabinet minister and attempt to murder. That's the case. Yes, my lord?
Yes.
And now the next page, top of the page. Rather, top of the page, rather the petitioner chose to evade due process of law by fleeing to Delhi. That's the case now. Why did I run away? I'm trying to evade the process of law on 4/9/25 to travel abroad. That, my lord, is their case. Now, my lord, if I can just kindly, before I read any further, I'm sorry, I forgot one thing. if I can take you to, my lord, my petition, sorry, my lord, for page 45. I'm sorry, my lord, for disturbing this sequence. Page 45.
Yes.
These are the video links, my lord, that they refer to. And we have video links of all that we are saying, that the police is saying. And if you, your lordship can see these video links, my colleague will, my lord, give your lordship the links. If you see video link number 3, your lordship sees, lordship has that video link number 3?
Yes.
Yes. APWWS demands action against minister for assaulting protesters. So this is why people were agitated outside. And at C5, video link number 5. This is the video link. What you may kindly make a little note. This video link shows the minister. He got irritated by the crowd, frankly. That's what happened. But my lord, ministers are always among the people. They're always crowded. People may come up to them. People, you know. He got irritated, and video link number 5 will show him rushing towards women and hitting them very hard with his elbow. Both his elbows he crushes. I don't know where he learns these things from. And that is the reason why people got very agitated, that it came in the papers and so on. But this is the video link which was carried in the video about the person hitting women with his elbows. You'll not see a single video link of anybody coming close to the minister, yes, my lord, irritating him, yes. Insisting, yes. Shouting at him, yes. But you'll not find anything relating to an assault. And he's surrounded by his police people. And my lord, he does this. I just wanted to show this, to put the agitation of people in context. Now, my lord, ministers are used to people irritating them. It's not like a big thing that they should get. Now, my lord, go back kindly to the counter. And turn, my lord, to page 146. We had read up to 145. Go to 146. And see with what casualness and haste. This is the LOC opening. It was done, my lord, on 2/9/25.
Page number?
That is, my lord, page number 146, internal page 13.
See, page numbers have been altered, so I don't think it tallies with what you're saying, so.
146, my lord. Annexure.
Annexure 1, my lord, Annexure 1.
Yes, my lord, Annexure 1.
Annexure 1.
Yes.
It's page 152 out here for me.
152.
And there is no internal page also.
Yes, 152. I'll make a note.
Opening of what, regular LOCs?
Yes, my lord. Now see,
Okay.
lordship remembers first summons he gave me. I go there on 30th. I gave a 2-hour interrogation. And then you send me a notice, appear on the 4th. Now see, he opens this. He doesn't wait even for a day. He opens this on 2/9/25. Notice which is received by my brother says appear on the 4th. And the LOC is already open. And if he's opened it on the 2nd, it means, my lord, 3 days earlier on 30th, I'd already given a 2-hour interrogation. Who operated that? Now, my lord, kindly see the witness statements. Kindly see. And they're all, half of these witness statements are copy-paste. Now see, my lord, I'll tell you the page numbers, my lord, 150. 155 it should be, Annexure 2.
Annexure 2?
Annexure 2, yes, my lord. This is the first witness. There are 3 witnesses. almost identical. Some paragraphs are word to word the same. Now, the first is one witness. First paragraph is the same. That doesn't matter. Now, see the middle paragraph. The proceedings of the meeting were going smoothly until they were disrupted by Ms. Banu Tatak, legal advisor. She interrupted Shri So-and-so and alleged that due to his influence, the Deputy Commissioner had filed an FIR and had Advocate Ivo Milli arrested. The rest is the same. Now, my lord, I ask myself this question. If in the middle of a smoothly moving meeting, she gets, let's say, upset with the minister and says, sir, why did you go and get him arrested? Right or wrong? Is that something like a cognizable offense? You're so sensitive. That's all. She told him, sir, you have got him arrested. Now, my lord, next paragraph. Despite the official clarification, Banu Tatak continued to spread misinformation and made false claims suggesting that Advocate Milli was being held unlawfully. Her statements appear to be deliberate, malicious, inciting anger. She's inside. She's talking to the minister. She's not going out. She has not gone out and spoken or incited the mob that he's done this, he's done that. The news is coming to her from outside. That Ivo Milli has been arrested and the same minister you're talking with is instrumental for that. Now, my lord, go to the last paragraph on the next page. So, my lord, inside is peaceful. Now, as we approached the exit, we were met with a crowd that had become increasingly aggressive. Some individuals in the crowd began throwing stones and chili powder. Others attempted to physically confront the MLAs. During the chaos, one individual so-and-so sustained a head injury from a stone. Additionally, a group of women, not me because I'm still inside, advanced towards him holding local knives. Fortunately, the security personnel intervened and prevented. All the videos will show nothing of the sort in terms of any attack on the minister, even by hand or whatever. The videos are clear and they rely on the videos. Now, my lord, the second statement is on the next page and it's almost verbatim. Second paragraph, third paragraph, word to word. And my lord, the third thing is thereafter. So there are three statements, almost identical. Yes, ma'am. So these are the statements you have. These statements don't involve me. What is the point in saying these statements? These don't involve me, except to the extent that I told the minister, sir, you have done this, it's not good. You have done it, and it's not correct. So because of that, you take me as if it's a cognizable offense. I can tell a minister something that he's doing something wrong. Now, my lord, go to the FIR, which is, my lord, the second FIR. That is FIR 18 of 25. That is Annexure 3.
Yes.
And see, my lord, the middle of the page where the incident is happening outside the conference hall. I'm not involved. Very categorical. The FIR is very categorical. Address outside the conference hall of DC office. Lordship found that? Middle of the page. That's paragraph 5B of the FIR. Paragraph 5B, sir. Annexure 3, paragraph 5B. Place of occurrence address outside the conference hall.
Yes.
Yes. So I'm not there as far as this FIR is concerned. Now, my lord, turn the page, I'll read this and then. It's the same as earlier, my lord, but I'll just quickly read. Paragraph 1. Initially, the SIFF executive members had invited me for the meeting, etc. That's my lord of background. Paragraph 2, I was assured by the executive that the meeting would be peaceful. 3, this is very important, that the meeting concluded, so beginning to end, on a very positive note at 5 p.m. So my role is over. I was coordinating, beginning to end. It ended at 5 and it concluded on a positive note, nothing against me. However, during the course of meeting, unaware to us, a mob of 100, 200 persons, disorderly and potentially, had gathered around outside the conference hall of DC. I'm inside. Now, my lord, go to paragraph 4. Sensing the gravity and severity of the situation, my security personnel advised me to stay in the DC chamber till the situation normalized. After waiting for 1 hour, I had to proceed to Tezu Lohit district. I was advised to leave. As such, I was escorted out by the security personnel. The entrance gate was blocked by the mob. The mob was aggressive and they kept pushing me. And the security personnel prevented us from leaving the DC. With the help of security, I managed to get away from the mob and was escorted towards the DC residential quarter, which is in the vicinity of DC office. When the mob was prevented me, a man in green coat threw chili powder, nothing to do with me, with the intent to. Also, when I was being escorted towards DC, an unknown lady tried to attack me, which was disarmed by my. On top of that, I was leaving the gate, an unknown person yelling, tried to land a blow at me, which was duly prevented. Lastly, as it was proceeding towards DC, a person from the mob threw a stone. Now, my lord, this is all mentioned in the anticipatory bail order. That it seems strange that even though you had videos and this has happened, you don't know the name and you don't know the person, even though it's caught on video according to you, of the person, and not a single person statement has been recorded regarding the identity of these people in my anticipatory bail. Now, my lord, paragraph 5 on the next page. That it has come to my knowledge. Who gave you this knowledge? That I was attending the meeting, that while I was attending the meeting, the mob gathered, instigated, and attacked. But during the meeting, I was there. I remained there. But they put my name here at the end, Advocate Banu Tata. The above named accused persons incited and instigated the mob. They spread a wrong narrative that Millie was detained by the police. That is why paragraph 9, that I remained in with my group, which is not denied in their counter, is very important for the case. Now, my lord, look at the next page, my lord. That is the notice for appearance dated 1/9/25. 2/9/25 is the lookout notice, my lord. 30th is the first time when I go and give my statement. 1 day later comes the notice for appearance. Just see this, my lord. And it is their case that because I was not there to sign, because I left on 30th. After I gave my statement, I had to go in the dark, in the night back. I left. Now see this, fellow. This is a totally formal, it's a kind of a bond. Just look at this. Although you are not being placed under arrest, you are directed to comply with. So I have to sign this document. You will not commit offense in future. You will not tamper. You will not make any threat. You will appear before. Of course, going without saying, I'll sign. And for this, you don't even need my appearance. You send it to me on email from my place, which is 9 hours away. I'll sign and send it back. This is the reason, the formal assurance which every accused gives. Is this the reason why you moved against me and took me off my plane going to Dublin? This is the reason. Now, my lord, kindly turn the page. This is their, my lord, I think it's their diary entry on 30th August 25. Lordship has that? It is the next page after what? 30th August 25.
Yes.
Yes. This is about when I give my statement. Go to the last line. Go to the last line. Second last line. Hence, he was asked to take rest for the night. They're telling me after taking my statement for 2 hours, take rest for the and appear at PS by tomorrow morning. For a detailed interrogation, she, however, remained adamant and insisted on recording her statement today itself. I don't want to stay near in a police station where my home is somewhere away. I'll go home. I'm a young woman, 25, 26, 27. Why should I stay in a police station or near a police station? So that's all. I insist that you take my statement. Full cooperation, 2 hours. Next page, Manu. Now, this is the now, this is where they say, this I deny. Mr. Banu Tattak left police station. She was served another notice with a direction to appear on 2/9/25 for a detailed examination, etc. The last line, she was unwilling to receive the notice and not cooperate. She was allowed to leave the police station. My answer to this is, you sent it by post. My brother received it on the 3rd. No, 2nd. My brother receives it on the 2nd. I receive it on the 3rd. And then I come to the police. After I come back, I come to the police station. So, my lord, these are their documents. Now, my lord, go to my rejoinder, and this will clarify the entire situation, day by day. Paragraph 2.
Yes.
Paragraph. First, I deal with the lookout circular dated so-and-so, 2/9/25. No reasons are given. Can't be. It's not a mechanical thing. Sumer Singh's case says you must show that the person has a non-bailable warrant. Second, you must demonstrate that the person is not turning up deliberately to evade arrest, etc. There are 3 or 4 conditions. You just give me a lookout circular straight away. And what date, my lord? 2/9/25. You have called me on the 4th to the police station for the 3rd summons. And on 2/9/25, without waiting for me to turn up or whatever, or to at least explain why I can't turn up, you sent a lookout circular in this casual and hasty manner. No reasons given why you're sending this. Now, my lord, Sumer Singh's case. Go down, my lord. Read ABC. Deliberately evading arrest. Not the case here. Refusing to appear in the trial court despite NBWs. Not the case here. There's no non-bailable warrant. There was no there was likelihood, this must be likelihood of the accused leaving the country to evade arrest. Now, my lord, the only reason why I was, because of my activism on the dam. I am quite an activist on the dam. I'm opposed to the dam. Many people are opposed. It may be wrong, it might be right. But as long as I don't break the law, you can't use a lookout circular to harass me. Now, my lord, kindly go down, please. Paragraph 4. There is no ground at all in the LOC. It was issued malified to trouble her because of her legal activism. It's perfectly law. Paragraph 5. The witnesses from 149 onwards of the reply uniformly show that the meeting organization went on peacefully and with due respect and decorum. Now, FIR 18 of 25, second FIR, that the meeting concluded on a very positive note at 5 p.m. However, during the course of the meeting, unaware to us, everybody in the meeting, a mob of 100, 200 persons disorderly potentially gathered outside the conference. Similar paragraph number 7, positive note. When they say positive note, I also take credit for that positive note. Paragraph 8. Now, this is what I pleaded in my petition. The petitioner was inside the DC chamber as part of the negotiating team. She was there with members for 1 hour. Officials were escorted out of the room by the police as there was an agitation outside the building. The petitioner and a group remained inside. There was commotion outside, but no violence and no attacks and no injury. Now the reply, my lord, the counter, that in regard to para 9, that is my pleading, the answering deponent begs to state that the petitioner is one of the accused persons who incited the violence due to which the officials were compelled to be evacuated by the police and army personnel on the date of the incident. As can be seen from the above reply, counter reply, it is not disputed that after the meeting was over, the petitioner remained inside the hall, even after the dignitaries and officials were escorted outside the hall by security guards. Para 11, petitioner was never outside during the commotion. It is true that people were agitated, but it is untrue that there was any violence at all. Paragraph M. Petitioner was present at the same place in the office premises of DCP where the incident occurred. Now, my lord, paragraph 13. On the contrary, video at serial number 5, that's the one I pointed out to you, shows the minister coming out of the hall and violently hitting the women with his helmet. This is unacceptable and illegal. And then, my lord, their allegation in para 10 of the counter. During the midst of it, the petitioner had attempted to leave the country without informing the investigating agency, despite a notice served on 2-9. So this I have to explain. Not my brother got it 2-9, I got it 3-9. Why did I not go? I have to explain that and give a reasonable explanation. The petitioner has not been quoted. Now, my lord, kindly see this one. Paragraph 15. Paragraph 15, my lord, is the old paragraph that I gave my statement for 2 hours. Now, my lord, paragraph 14 and 15, when the letter reaches my brother on the 2nd, why did I not turn up? I have to answer that squarely to satisfy your lordship. 14. On 3/9/25, a letter was delivered to the petitioner's house. They say 2-9, we say 3-9. And she was asked to report to the SIT branch. Now, my explanation. However, petitioner was unable to report because she had already booked a flight ticket from Dibrugarh, Assam to New Delhi on 4/9/25. I can't come because I booked a ticket. I was to go from Dibrugarh to Delhi and from Delhi to Dublin. And the date of the booking of that ticket was August 2025. I'll show all that now. It's not that I suddenly went and booked the ticket and ran away. I booked a ticket in August. Now, let's see this. The time taken for the petitioner to reach Itanagar from her residence would be approximately 8 hours. And it was dangerous for her to travel at night. Hence, it was impossible for her to go to Itanagar as requested by the police to reach on 4/9/20. There was no evasion on petitioner's part at all. And that shows subsequently. Next summons, she goes for 4 hours interrogation. So no evasion, obviously. However, moreover, the petitioner had submitted a comprehensive statement where she spoke for 2 hours to the ZS. Now, my lord, kindly turn the page. Paragraph 11 and 12. 11 is the same, my lord. I went earlier and gave her two. Now, paragraph 12. The answering deponent states that the notice dated 1/9/25 was duly served to the petitioner, which was received by her elder brother on 2/9/25 and not on 3/9/20. This is what they say. The petitioner is trying to mislead them. Now, my lord, paragraph 13. This is what they say. The answering deponent states that notice dated so-and-so was duly received by her brother, etc. However, the petitioner deliberately refused to comply and instead left for Delhi to travel abroad. So they know I'm traveling abroad. They must go and see whether I'm doing it deliberately, suddenly going and booking a ticket after I get summoned and go abroad. Now see this one. Paragraph 17. That the IO recorded the statement of the petitioner for 2 hours and typed on his is not denied in the counter. Now, my lord, kindly turn. Paragraph 19. Now see what happened. My explanation. After I reached home, gave statement on 30, reached home. What is my explanation? Paragraph 19. Petitioner emphatically denies the above averment that I'm deliberately evading. After her examination on 30/8/25, she went back to her home in Lower Dibang Valley on 1/5/25. Took 8 hours for her to reach home. On 2/9/25, petitioner was not at home because she went for her LLB classes in Namsai. She was in Namsai for the whole time on 2/9/25 and returned home only on 3/9. Thus, only when she returned home on 3/9/25 did she receive the second summons, which was served on her brother at her home on 2/9/25. However, the petitioner's air ticket to go from Dibrugarh to New Delhi on 4/9/25 by an afternoon flight was booked so that the petitioner could spend some time with his sister in Delhi before taking the flight from New Delhi to Dublin on 7/9/25 at 3 a.m. The copy of the flight ticket from Dibrugarh to Delhi above mentioned is annexed. And that, my lord, if your lordship please sees R1. R1 of this affidavit. The date of booking is 26th August 25. I had booked it 1 month in advance, is it? Anyway, it was booked prior to my giving first summons appearance. That is at page R. And then your lordship will see the next page, R2, is my flight to Dublin. That is also booked on, your lordship will see top of the page, R2, top of the page. Document issued 25th August 25. Lordship has that, R2? Yes. Right on top, document issued 25 August.
Yes, I've seen it.
So Dublin I booked in advance. So I'm not evading. I'm telling him, sir, I can't afford. If I don't take the flight, I have to go. I'll lose my class. So there's, my lord, go back again, my lord, to paragraph 21. It was impossible for her to go. Paragraph 21. Thus, it can be seen there was no avoidance at all. It was impossible for her to go all the way from her home to Itanagar, which was 7 hours away, to answer a second summons. Secondly, it was pure harassment because you had taken my statement for 2 hours. Then to insist that I go for another 8 hours to Itanagar, and the sequence of the flights booked by the petitioner shows it was impossible for her to attend the police station. And it was not only impossible, it was dangerous for her to travel by night. Then, my lord, I say at page 22, the summons dated 1/9/25 is a formal summons. It's not for me to go and have my statement recorded. It is to sign that assurance. I will not commit an offense. I will not do this. I will not do that. which you can do, I can do it even online. There's no problem at all. Now, my lord, para 23. Para 23, 24, my lord, I'm saying the same thing, no evasion. Now, my lord, the third summons. The proof of the pudding is in the eating. You send me a third summons, do I run away? See this, my lord. By letter, para 25, by letter dated 7/10/25, the petitioner received her third summons to appear before the police on 10/10/25. Petitioner appeared before the police, because now I'm taken off the flight. Petitioner appeared before the police and was interrogated for 3 hours. Then she was asked for certain bank papers. Now, my lord, now they're going on a different track. When they answer your lordship, they are asking you, what are your entries in your bank account? So she says, I get 1 lakh in this month, 2 lakhs in this month, because she's doing certain projects for university related or some kind of work abroad, some kind of academic, 2 lakhs, 3 lakhs, 1 lakh. So now they are not interested in summoning her regarding the incident, regarding shying away or whatever. They're not. All the summons questions are, give us your bank account details. So she's given them. Now they've sent another interrogatory. Explain why you got this money, from whom you got this money. Was it legal for you to get the money? Nothing to do with the case on hand, my lord. Nothing to do. That, my lord, is the summon substance of my case, and I'm very grateful. I finished now.
Yes. You may argue.
Yes, my lord. My lord, may once again peruse, my lord, annexure 3 of my affidavit of opposition, my lord, FIR, my lord.
Annexure 3.
Yes, my lord. Page number 162, my lord.
Yes.
My lord,
Second FIR.
this one is second FIR, my lord.
Second FIR.
Yes, where the alleged accused person name is categorically mentioned, my lord. And my lord, if you read the fourth para, my lord. May I read, my lord?
Yes, please read.
That sensing the gravity and severity of the situation, my security personnel advised me to stay in the DC chamber till the situation normalized. However, after waiting for about 1 hour in the DC chamber, and also as I had to proceed to the Teju Lohit district, and I was advised to leave the office premises before darkness sets in. As such, I escorted out by the security personnel. The entrance gate of the DC office was blocked by the mob. The mob was very aggressive, and they kept pushing me, and the security personnel preventing us from leaving the DC office premises. However, with the help of the security personnel, I managed to get away from the mob and was escorted toward the DC residential quarters, which is in the vicinity of the DC office. When the mob was preventing me from leaving the office premises, a man in green Adi coat threw chili powder at me with intent to cause harm to me. Also, when I was being escorted toward DC residence, an unknown lady tried to attack me with a local knife. Which was disarmed by my PHO, my lord. And my lord, if I turn to next page, my lord. And here, my lord, the name of in FARA 5, my lord, the name of this petitioner, my lord, is mentioned in FARA 5, clause D, my lord. Yes, my lord. Now, my lord, allegation against the petitioner, my lord, accused person, was that, my lord, she was the one who instigated the mob, my lord. And the mob tried to mishandle the informant, my lord, who is the minister or the government of Arunachal Pradesh, my lord. They tried to mishandle the minister, and they also threw chili powder, and they some of the members were part of the unlawful assembly. They tried to attack the minister with the knife, my lord. So that is the main allegations against the this in the FIR. And this petitioner, who is being part of the mob, who is also was the part of the mob, was equally responsible under 189 BNS, my lord, one unlawful assembly, my lord. She was also part of the unlawful assembly who tried to attack the minister with the weapon, my lord, with the local knife, my lord. So, my lord, to substantiate that this very FIR, my lord, the statement, my lord, which my lord has also produced earlier, my lord, the phase number 157 of my affidavit of opposition, my lord.
137.
157, my lord. 157, my lord.
57.
Yes, my lord.
Yes.
My lord, may have phase number 159, my lord. Phase number 159, my lord. Phase 159. Yes, my lord. This is a statement of the PSO of the minister concerned, my lord.
PSO.
Yeah, PSO, my lord. May I read, my lord?
Yes.
On being examined, I state that my name is Sri So-and-so, a constable currently serving as a PSO to Sri So-and-so, Honorable Minister. The indigenous Siang Farmer Forum, SIFF, organized a meeting at the conference hall of the Deputy Commissioner Office in Boling to discuss public concerns regarding the proposed Siang Upper Multi-Purpose Project. The meeting was attended by stakeholders including so-and-so, and my lord, next Farah. The proceeding of the meeting were going smoothly until they were disrupted by Ms. Banu Tatak, legal advisor to SIP, the present petitioner, my lord. She interrupted Sri Ojing Tasing, who is the minister, my lord, and alleged that due to his influence, the deputy commissioner had filed an FIR and had advocate Ivo Mili arrested. She claimed that advocate Mili had been missing and implied that the police were involved in unlawful detention. In response, both the deputy commissioner and the superintendent of police clearly stated that advocate Mili had not been arrested and refuted the allegations on the spot. Next, Farah. After the meeting concluded, both the MLAs along with the deputy commissioner and the ADC were unable to exit the conference hall due to the escalating situation outside. The tension was caused by the spread of misinformation and false claims regarding the alleged difference in detention of the advocate Ivo Mili, which created unrest among certain participants. Next page, my lord. In response to the growing disturbances, we proceeded to the DC chamber located on the first floor using the staircase. After an hour, as it was beginning to get dark, we attempted to exit the premises. At that point, the crowd had become increasingly aggressive. Individuals began throwing stones and chili powder, and some tried to physically confront the MLAs. MLAs means that is my lord, minister, my lord. During the chaos, one person sustained a head injury after being struck by the stone. Additionally, a group of women approached Sri Ojing Tasing, two of them holding local knives, locally known as yoksik. I managed to disarm them by pushing their hands away from the Ojing Tasing, who is the minister concerned, preventing a direct treat, my lord. So, my lord, the allegation against this petitioner is, my lord, she was the one who conspired the entire incident, my lord. She instigated the mob, and the mob, which has mishandled the informant, my lord, and they tried to also cause harm to the minister concerned by trying to attack the minister with a knife, my lord. So that is the main allegation, my lord. And my lord, 108 abatement, this one attempt to murder is also registered. When, my lord, the learned senior counsel submits that there is no cognizable offense has been made out, my lord. The cognizable offense has been made out against the accused person, my lord. And, my lord,
By the way, what is the stage of the investigation?
Investigation is going on, my lord.
Going on?
Yes, my lord. Investigation is going on, my lord.
How many FIRs in all?
There are total 2 FIR. And
FIR.
second FIR, the petitioner is named, my lord.
Not in the first FIR.
No, not in the first FIR, but he's also accused in the first FIR. He's also accused in the first FIR, but his name is not mentioned in the first FIR. That's a my lord, C, my lord. My lord, may page number 164 of my affidavit of opposition, my lord, page number 164. Sorry, my lord, page number 165, my lord, 165.
Which is the first FIR? 161?
First FIR, my lord, we have not annexed in our affidavit of opposition, my lord. That is in their petition, my lord.
Then what is this 161? This is the second FIR.
No, my lord, this once, yes, my lord, this is second FIR, my lord.
Second
Once,
FIR.
yes, my lord.
Where is the first FIR?
My lord, first FIR,
Page?
Page 7 of the petition.
page number, my lord, 38. No, my lord, page.
32 to 37.
Page number 33, my lord, is the first FIR, my lord. Page number 33
Of the writ petition.
of the writ petition, my lord.
It starts from 32, I think.
It starts from 32, my lord. 32,
This is the
33.
first FIR.
Yes, my lord.
Okay. Her name is not there, but she's involved.
Yes, my lord. And my lord, may fair use the page number 160, 65 of my affidavit of opposition, my lord. Why I am showing this, my lord? Because from the very initial, my lord, the conduct of the petitioner was, my lord, non-cooperative one with the investigation agency, my lord. Page number 165, my lord.
Just a minute. Before that, the second FIR is at page
Page number
161.
160 of my affidavit of opposition.
And the name of the petitioner is at serial number 4.
Serial number 4 of the paragraph number 5.
Column number 7. Column 7, I think.
Column 5, my lord.
Column 5. Column 5 doesn't have any name.
Oh, my lord. Yes, my
Column
lord. Right.
7.
1, 2. Column 4, my lord, in the FIR, my lord.
Are we on the same page? Page 161, annexure 2. Right, annexure 3.
Annexure 3, yes, my lord.
Page 161 in my copy.
My lord, details of the suspected person, my lord, that column, my lord.
That's what?
Yes, my lord.
This is column 7.
Yes, my lord. My lord.
It
Yes,
said 4.
yes, yes.
Okay, now you want me to see which page?
My lord, the page number 165, my lord.
65.
Yes, my lord.
Yes, this is the
Yes,
general.
a general diary entry, my lord.
details.
Yes, my lord. May I read, my lord?
Yes, read.
Now, Miss Banu Tata, the petitioner, my lord, daughter of so-and-so, appears at this PS in connection with bowling PS case number so-and-so, 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 under section so-and-so, bite our summon dated 28/8/2025. She was directed to appear today at 11 hours, but she reached late. Since she is late and it is already sunset, hence she was asked to take rest for the night and to appear at PS by tomorrow morning for the detailed interrogation. She, however, remain adamant and insist on recording her statement today itself. And my lord, next page, my lord. Next page is also general diary entry. Now, Miss Banu Tatak, the petitioner, left PS. She was served with another notice under section 35(3) VNS with a direction to appear at PS on 2/9/2025 for a detailed examination in connection with, as since in the first, my lord, in the summon where she was appear, my lord, and at that time it was already sunset. So thereby, my lord, the IO has insisted that the statement be recorded tomorrow, since it's already a sunset. So, but she insisted that it should be recorded today only. So that's why, my lord, again on the same day, the IO of the case was trying to serve another notice, my lord, to appear on, may I read, my lord? to appear on 2/9/2025 for the detailed examination in connection with bowling fees case number so and so, so and so, so and under section so and so. C, however, refused to receive the notice. My lord is having the page. Page number 166, my lord.
What is the difference between these two? The first one is at page 165.
The first one is, my lord, when C appeared and the IU told him that it is already a sunset, but she insisted on recording her statement on the same day. But again, since interrogation was not completed, therefore IU had served him another notice on the very same day.
But it was already there. What is the requirement of serving another notice?
That's saying because my lord, her statement was not completed, my lord.
So you could have continued it.
Her statement was not completed, so she was directed to appear on 2nd September, ma'am. However, she refused to accept the notice despite being asked to cooperate with the investigation. Also, she was unwilling to receive the notice. Receive the notice, my lord. And my lord, thereafter, my lord.
What you mean to say is on 38/25, statement was recorded.
Yes, my lord.
It was not completed.
Not completed, my lord.
So she was asked to return, come back next day.
On 2nd, my lord. Second.
So that notice was given to her.
Yes, my lord.
And she refused to accept.
She refused to accept.
Okay. Where did you give the notice? In the police station?
In the police station, my lord.
Then what was the requirement of sending it home?
My lord, since
it was received by your brother?
Because he was reluctant to receive the notice, my lord.
Okay.
Yes.
So you had sent to the house?
Yes, my lord.
Her home. Okay.
So next page, my lord, 167, my lord. Last page, my lord.
Yes.
167, my lord. This one is a notice, my lord.
This is a notice?
The second notice, my lord, which was where she was, my lord, directed to appear on 4/9/2025, my lord. 4/9/2025. And this 4/9, that is in the first para in the last portion, my lord. Hence, you are directed to appear before on 4/9/2025. And below, my lord, down below, my lord, received by, my lord, Dibang Tatak, my lord, on 2/9/2025, my lord. Brother, my lord. This, they are saying that, now they are saying that this was received on 3rd only. Now we are saying that this was received on the 2nd only.
But by the brother, not by her.
Not by her.
She was out, so she didn't receive it. That's what they say.
But my lord, have used the 1 year ticket, my lord, that has been that is annexed in the rejoinder filed by the petitioner, my lord. That's
yes, which one?
180, phase number 180, my lord.
Yes.
180 of the rejoinder, my lord.
Yes.
There is one. There is air ticket that was already booked on 26 August 2025. However, my lord, such kind of intimation was not given to the, my lord, police, my lord, that she is living out of the India for this whole academic purpose, my lord. So therefore,
was
my lord,
there any bar as such?
My lord, since, my lord, in the bail condition also, it is categorically stated that she has to cooperate with the investigation as and when called for, my lord. So she is going for the country for 3 months, my lord. Investigation is still going on, and her statement was to be recorded again, my lord. In the mid of the investigation, she was abruptly, my lord, going outside the country, my lord. That too without informing the investigation officer. There is no formal communication, my lord, made to the IO of the case that due to this and that program, I am going outside the country. There is no such communication, my lord. And my lord.
So investigation was going on. So any any plans to be away from the country should have been informed by her,
Yes, my lord.
according to you.
Yes, my lord. Since his statement was already, she was already directed to appear on 4/9/2025.
No, but did you put her to notice that, see, we are having investigation, you cannot be far away, you cannot leave the country like that, anything like that? No indication.
No such indication, my lord.
So you assume that since investigation is going on, she cannot leave.
No, my lord. Our cases, my lord, since she was directed to appear on 4th September, my lord. 4th September. 4th September. She was directed to appear on 4th September.
No, correct. 4th September, she was supposed to appear, notice refused to be accepted on the day she was in the police station. So you send the notice to the home where brother had received it, whereas she said she received it on 3rd. But explanation is that I have a ticket to Delhi. On what? Travel to Dublin. And then you say that there was no prime information to us about her leaving abroad. So hence the justification of the LOC.
Yes, madam.
Correct?
Yes, madam.
Okay. Then?
And my lord, very recently also, my lord.
No, she has not traveled now, isn't it?
Not yet, madam.
So now, why don't you make use of this time? They make all the investigation you have to. Any questions you have to ask.
Now, my lord.
What is happening now?
Now, my lord, she appeared after this one LOC. She appeared once.
When?
And that, my lord. Someone was issued on 10th October, my lord.
What is this you're giving me?
My lord, this one is, my lord, she was directed to, my lord, may I read, my lord? In continuations to our earlier summon of event number dated 10 October 2025, you were directed to produce the following information documents which were not been furnished to this until date. You are required to furnish the following: 1. Details of remitter of the mentioned transactions with full details of the transaction. Supporting documents of all the investigation, all the aforesaid transaction which proves that the transactions were legit. The reply may be furnished to the undersigned by 2nd December 2025, my lord. Now today is 5th, my lord. Now also, my lord, if see the conduct of the accused person from the very beginning, my lord, on the day when she appeared before the police station, she insisted that her statement should be recorded, whether it's going to be sunset. But again, she refused to accept the notice. And now again, my lord, she was directed to give the details of the remitters of his bank transaction, my lord. Because there is some investigation has found out that there is some transaction has been made into his account while she was supposed to travel to Dublin, my lord. So this information is also not yet been furnished to the investigation authority, my lord. So, my lord, my humble submission is, from the very beginning, from the inception of the investigation until now also, the petitioner is not cooperating with the investigation agency, my lord.
Okay, now this letter you've given me, it's a reminder 1. Where are the previous letters?
That, my lord, that I don't have, my lord.
Then it says earlier summon event number dated 10 October 2025. Where is 10 October? Where's this summon?
My lord, if give me time, then I can furnish, my lord. If, my lord, if give me time.
No, the reason why I'm asking you is this because is neither here nor there. Details of remitter of mentioned transactions. There is no details. There is nothing mentioned. So what should one produce?
Well, she was directed to produce the details of the transaction.
Which transaction?
Bank account.
It can be any transaction.
Bank account transaction, man.
You go to the market, buy vegetables transaction.
Bank account transaction. Bank account transaction. Here
so that detail has to be given in this notice. Where is that?
That, my lord, I think that should be in earlier summon, my lord.
That is why I asked you the earlier summons. You don't even have that. So how do you know what is required to be produced?
In that case, my lord, if...
and this is supposed to be an investigation.
Yes, my lord.
You have to be specific what you want. That you are a holder of this account in this bank, and within this and this, we see some transaction going on. Where are the details? Where and how, whom, like that.
Exactly, my lord.
That should have been in your notice.
My lord, in
So
that,
just simply saying details of remitter mentioned transactions with full details. Give us that. From
so
where?
this much they have furnished me as of now, my lord. In that case, my lord.
No, you should also ask, isn't it?
Yes.
Ask your clients. I am to produce this to the court. If the court asks me, what will I say? The previous summons may perhaps indicate
My lord.
10 October 2025, and that you don't have it. Hmm?
In that case,
No, you carry on. What do you want to say?
so my lord, this is my submission, my lords. From the very beginning of the investigation, the conduct of the petitioner is non-cooperative, my lord, with the investigation agency, my lord.
So the investigation is at what stage now?
Investigation is still going on to ascertain, my lord, the
Going on means what? How long? will
the
it go
statement
on?
of the witnesses are being recorded, my lord.
How many?
Most of them recorded, I think, my lord. But still, since there was
No, you need to give us that proper status, proper fact and figures. So far, we have identified this much of witnesses, and out of these witnesses, we have examined this much.
my lord,
we
in that
require-
case, I may be allowed to produce a case diary, my lord. Case diary, by Monday, I can produce my case diary.
This is registered where?
My lord, this is, my lord, this is one.
Itanagar?
Itanagar only, SIT, crime branch, they are taking up the cases, my lord, matter.
Now, how long? Where's that LOC? Lookout circular.
LOC is page number 100.
100?
152,
Of the-
my lord. 100.
Of the rate petition.
Not my, of my affidavit official, my lord.
Page
Affidavit-
100?
152, my lord, 152.
152.
Yes, my lord.
Does it have any such kind of duration for this life of this LOC?
My lord, it is, if we read the first para, my lord.
Read.
The black one, my lord. This LOC shall remain in force until and unless the deletion request is received by the BOI, Bureau of Immigration, from the originator itself, my lord. So, unless the deletion request is being made by the originator, my lord.
Originator is?
Originator is the, my lord, the SIT, my lord, who had issued the LOC, my lord.
So where is the LOC?
This one is the LOC, my lord.
This is the LOC?
Yes, my lord.
No, what has the originator written to the ministry?
Oh, that, my lord. That is, my lord, we did not annex here, my lord. That is not with us, my lord.
What is the date of the LOC?
LOC, 2nd September.
2925.
Yes, my lord.
Does it have a reference from the originator?
Yes, my lord. Originator
Where is the
is,
reference?
originator is at, my lord, below. Superintendent of Crime, SIT Police,
Where?
headquarters. My lord?
No, my lord. First part is the memo number, my lord. With respect to the letter, oblique memo number, so and so, PSQs, crime branch, PS, so and so, dated 2nd September 2025 is the reference number.
So it is intimated that as requested, opening of so and so has been completed at our end. So the same day, is it? 29.
Yes, my lord. 29.
PHQ's letter is 29. And the Bureau of Immigration
Yes,
has
my
also issued this on 29.
29, same day, my lord.
And this will remain So long as the same is not deletion of the same is requested
Yes, my lord.
from the originator.
Yes, my lord.
So that is how it works.
Yes, my lord.
Okay. Then please read the next line.
Next line, originator agency must keep reviewing the LOC offend at its behest on regular basis. In all cases where the accused is no longer required by the originator agency or by competent court, the LOC deletion request must be conveyed to the BOI immediately.
So this reviewing thing should happen when? This was issued on 2/9.
Yes, my lord.
September. We're in December now. Has there been any developments in this regard? Or you stick by this reference?
My lord, in that case, if CD and if I may be allowed to take instruction, my lord, then
Monday?
Monday, my lord.
Monday is what date?
Monday is 8, my lord.
7th?
8, my lord.
I'm sorry, it's 8.
Yes, my lord.
Would you like to say something?
Malad, as per the Malad affidavit filed by the Malad, the only role of the respondent number 2 and 3 is Malad, Lordship may kindly peruse the same Malad, the LOC page number. I'm on page number 153, Malad, same affidavit filed by the respondent number 4. Malad, important point is given, important non-copy to important note, Malad.
Which page?
Malad, on LOC again, Malad.
Again, LOC, yes.
Affidavit of opposition, my lord.
Just below, Malad.
Page 152.
Correct, Malad. 53, Malad. Type copy is 53, Malad.
Okay, yes.
The LOC can be originated, deleted by the officers of the rank of the so-and-so, the contact number so-and-so, Madam. Madam, it is given to the Superintendent of Police, Crime, SIT Police Headquarters, Itanagar, Arunachal Pradesh, down below, copy 2. The important note, accountability of the executing LOC shall lie with the originator, Madam. The not with the BOI. The hence, all relation of the court orders must be conveyed to BOI by originator only and not by LOC subject. Next page, Manoj. All requests regarding LOCs should be made giving LOC number so-and-so acknowledgement. The originators of the LOC is requested to strictly prevent unauthorized access of these classified documents to LOC subject or his or her representatives or any other authorities. Well, by these documents, what I want to make submission is completely it is the originator. Originator is, if I'm correct, is the respondent number 4, and therefore that has been issued. In their affidavit also, it has been clearly mentioned at page number 141, same page, affidavit file button 141. That pursuant to para number 2, the answering deponent states that a lookout circular was issued by the Bureau of the Investigation, Ministry of Home Affairs, Government of India, against the petitioners on the basis of requisition made by the Superintendent of Police Crime Branch, Headquarters, Italy. So my submission is, everything has been, of course, it has been done by the BOI, the Bureau of Investigation. So responsibilities, everything is on the
counsel for the respondent number 4.
Yes, my lord.
You can get the instructions by Monday.
My lord.
Along with the updated case diary.
My lord.
Sure?
Yes, ma'am.
Mr. Gonsalves?
Please, sir.
We have this again on Monday. I would like to see the updated case diary and instructions regarding whether there was any review of this LOC or not in the meantime.
Yes.
Please write down, Hart.
Can I say something for a minute?
Yes.
1 minute only.
Yes.
You cannot have an LOC without a reason for an LOC. The reasons are in Sumer Singh's case, he's evading, there are non-bailable warrants, etc. There's a trial going on, etc. This LOC has no reason at all. So we had to guess what is the reason, and that guesswork was that incident out the DC office was the reason for LOC. Now, my lord, they have stopped that investigating completely. After I went for the third summons on 10/10, 10th of October 25, they lost interest in that now. And now they are looking at bank account. Now, what is my bank account? 2 lakhs, 3 lakhs, not that I'm a millionaire. What has my bank account to do with the original reason for opening the LOC? If that reason has expired or it's become old or it's become ineffective, set it aside and let me go abroad again. 3 months I want to go and come back.
All right. We'll see to that. We have heard the parties, otherwise, just the last minute clarification I require on that point. Hart, Mr. Hart, Dr. Colin Gonsalves, Ladat Senior Counsel, assisted by Miss Sunny Tayang, through RVC for the petitioner. Stop also heard Mr. M. Kato, learned DSGI for respondent numbers
2 and 3, madam.
2 and 3, and Mr.
El Kurdu,
you are PP.
SPP, madam, Special Public Prosecutor, SIT.
El Kurdu, learned special PP, SIT for respondent numbers
4.
Respondent number 4. Next para. Grievance of the petitioner in filing the instant writ petition is mainly on the issuance of the lookout circular bracket LOC at the behest of respondent number 4 by the respondent numbers 2 and 3. That is the Bureau of Immigration, Ministry of Home Affairs, on 2/9/2025, and for which reason the petitioner could not travel abroad to Dublin pursuant to an invitation made to her by the university.
By the Dublin University.
By Dublin University. Snob Learned Senior Counsel for the petitioner has strenuously made submissions that the LOC issued is without any basis and cannot stand the scrutiny of law in terms of the various decisions rendered by the Apex Court. And therefore, the same should be interfered with by this court. Next para. The LOC in question has originated pursuant to the 2 FIRs registered who has registered the FIR? Registered before Boleng PS. Can you tell me the numbers of the FIR?
My first
This
FIR
is too minute, you see. You have a
FIR number 11, first FIR, madam. First FIR number 11, madam.
What is the reference? Or at least tell me the date.
Madam, date is 28/5/2025.
on 28/5/2025. And the second?
Second is following case number 18, my lord.
And White FIR number 18 of 2025, dated 11/6/2025. So although the name of the petitioner has not been specifically named in the first FIR, comma, her name appears at serial number 4 amongst the details of the known oblique suspected oblique unknown accused with full particulars column at serial number 7 of the FIR. Although the parties have been heard at length, but in order to know what is the current status of the investigation carried out by the authorities, the learned special PP shall produce the updated case diary by the next date. And also, obtain instructions as to whether where's that LOC?
Case number 153, my lord. 53 of affidavit of official, my lord. (52) 53 is a type copy. 152.
As to whether there has been any proposal oblique attempt on the part of the investigating authorities to review the LOC, and if not, comma, the reason as to why the same has not been done. List again on.
It can be on Tuesday, my lord. 9, my lord. 9. Monday will be little early, my lord.
That is why I asked you again.
Yes, my lord.
But it has to be by 9th. Okay.
It can be on
Don't
8th.
take beyond that.
Very helpful for
Sorry?
me. 8th will
Sorry?
be pretty convenient for me.
But Mr. Gonsalves, I've heard you already. So even if you have some difficulties, I think we need not go back into the thing.
Whatever
Okay.
you decide. Whatever you decide.
Because let him have some time, because today basically it's
yes,
we can call it a day because the authorities will not be around. So list on 9th of
Would your
December.
lordship part heard, my lord, since we've almost finished?
I will not say the part hard, but you take it, it should be understood that is a part hard matter.
My lord. My lord.
My lord, on 9th, my lord, my presence may not be, my lord, required, as because I'll be having some personal difficulties on 9th.
Surely, no problem.
Oh, nice.
Item number 7 to 9.
Yes.
But this matter also otherwise involves only a small
Lord,
issue.
we can straight away take up with the writ petitions.
Item 9.
Item 8 and 9. Subject matters are the same, but item number 9 is more polished. Anyway, my lord, we will start with item number 8.
I don't know.
Only
Subject to what you all say.
only on the principle we have to decide, my lord.
whether once the DPC proceeding has been initiated, can the rule of the game be changed? Lord, it will take at least half an hour for us.
Can we have it some other day?
Yeah. My Lord, may I propose that it may be taken up on 10 and let it be on top of the order because there is some urgency from all sides.
10 is what?
Wednesday.
We have matters fixed on Monday. And
Yes.
Tuesday also, few
Yes.
fixed matters.
So Monday, Wednesday 10th or
Wednesday,
11th.
I'm not sure. You don't keep a note, is it? About what matters are fixed? Definitely, we'll give it a try. 10th, you all are here?
Yes.
If it
Well,
can be on Monday.
let it be mentioned that
Monday.
it is on the
Monday will-
Monday there
we
is
have
a
some
lot of
matters,
cases has
so-
been fixed.
That's why. And we never know, suddenly we might have DB also again.
Yes.
So 10th we'll have it. This is what in the admission column.
Yes. Admission column.
Did it come up with the first item in the admission?
Yes.
Okay, please write, as paid for by the parties, list this matter on 10th of December 2025 as the first item in the admission column.
Obliged, madam.
Obliged, Lordship.
Item number 13 to 14.
Yes, this is for orders. Why it's listed for orders today?
My please, Your Honor. My lord, this is IM matter regarding the interim prayer, which not in the continue and on the point of time when the motion is going on, my lord. So it is IA for the interim prayer regarding the stay order for impugn advertisement which enclose annexure 8, page number 82.
What interim prayer are you seeking? You are the
Yes.
petitioner.
Yes, petitioner side, my lord.
Okay. What is the interim order you're seeking?
Yes, interim order regarding the stay regarding this advertisement regarding any recruitment process, whether in the interview, advertisement regarding the some portions which should be completed regarding the interview or another any kind of the examination regarding this advertisement. Because, my lord, we just fight regarding the native domicile of the Arunachal Pradesh, 50-50 portion regarding that. So this NIT of AP is never ever followed the guidelines along with the 4-tier system of the NITs, which already prevail since from the 2011. So my simple prayer, Your Honor, temporary stay disorder till the disposal of the suit or the other party supposed to become.
No, I think, where's the writ petition?
Yes.
Who's there for the other side? You are there?
My lord, I'm for the respondent number 1. My lord, all my lord, advertisement, everything has been done by the other respondents, my lord.
Who are
And,
they?
last occasion, my lord, the service was not completed, my lord.
Who are the other respondents?
Other respondents are, my lord, the institute, my lord.
You are the Department of Higher Education, Ministry of Human
My
Resources.
lord, I'm for the respondent number 1, my lord.
And the other one is Director of NIT.
My lord, NIT, my lord. They are
Is there any standing council?
Earlier, they appointed one standing council, namely, my lord, Mr. Gagum Lawlen, my lord. And as of now, my lord, we don't know, my lord. Therefore, my lord, service has to be close to the, my lord, the other respondents, my lord.
Lolan is not there anymore.
My lord,
Then who's appearing in the main writ petition then?
my lord, service is not yet completed, my lord.
Is it so?
Yes, my lord. I am keep on appearing on behalf of respondent numbers. My lord, my lord, actually, we don't have any much role to, my lord, play in such recruitment process, my lord. It has been completely done by the, my lord, other respondents, my lord.
Okay, that's what you have said already.
Yes, my lord.
Now, NIT, where's the location, NIT?
Jyote Itanagar.
Why don't you serve notice to them by way of Dasti? I'll permit you that,
That's true, Your Honor.
both in the writ petition and this one. And we issue notice on the interim prayer also. So that we consider it next date by the presence of whoever's going to appear on their behalf.
Your Honor,
Have you taken steps otherwise?
in the main case, I take the steps.
Then
But the-
when was it taken?
The taken on
2811.
yes, 2811, Your Honor. The main case already is to take the steps.
main case today, we are only concerned with the IA, isn't
That's
it?
true, that's true. But when I seen the steps taken regarding, then no any steps taken by the staffs, Your Honor, because the no any specific order regarding the issue notice or steps taken by the in our side. But in on that day, Your Honor, I already submission regarding the issue notice.
No, what are you saying? I don't understand what you're saying.
Your Honor, as per the last order dated, there is no any issue of notice of the other party in this IA case. So no steps taken as per the
Not
official
the
record.
IA, I'm talking about the writ petition.
Or writ petition, Your Honor. The steps already taken, Your Honor. 28/11/2020. Service, yes. Register post and ID card already done, Your Honor. But it's still
And
awaited.
in the IA, though, notice has not been issued. So
Yes.
there is no question of you taking steps.
That's
Right.
true, that's true, that's true.
So in the
I
last
accept it.
order, it says that Mr. Bagra has sought time to find out whether there is any standing counsel, NIT Jote, and therefore list today. You are Mr. Bagra.
I'm the Bagra, my lord.
So have you found out whether they have any standing counsel or not?
Your Honor, no any standing counsel available.
So
No steps,
permitting
no.
you to take steps by way of Dasti. Heard Mr. What Bagra?
M. Bagra, Morik
Heard
Bagra.
Mr. M. Bagra, learned counsel for the applicant, who submits that by filing this application, the applicant, who is also the writ petitioner, prays for an interim order. What kind of interim order you're saying you are praying for is also not properly mentioned here.
Your Honor, only no point of time, Your Honor. In page number 82, annexure 8, just for a stay
You
regarding
straight
that.
come to your prayer portion.
Yes,
What
my lord.
stay? What interim prayer are you making? You should be very clear.
Yes, my lord.
Immediately stay those faculty don't write, huh? Immediately stay those faculty positions recruitment under notification advertisement number so and so, and any other faculty recruitment national. So what is this? It's neither here nor there.
Your Honor, it's reflected advertisement number NITAP faculty requirement ad 0124 dated 08/2/2025. Your Honor, this annexure 8, page number.
For which post?
Post not specifically mentioned, but in the petition already mentioned, Your Honor.
You want to stay for the entire recruitment?
Only this advertisement, Your Honor. Advertisement recruitment, Your Honor.
Advertisement you stay, that means the entire recruitment is stayed.
Yes, my lord.
So recruitment is for which post? Advertisement.
Yes, page number 82, annexure 8, my lord.
No, you tell me like that
Yes.
without pointing out the page number and all that.
Yes, my lord.
The advertisement is for what post?
Electrical engineer for the assistant professor, Your Honor.
Assistant professor in electrical engineering.
Engineer, civil engineer, mechanical engineer, and computer science and engineer. Total 5 posts, Your Honor.
All.
The divided into ratio of SC OBC and PWD OBC divided into 2, 2, and 1 regarding the post of this recruitment, faculty recruitment, Your Honor, my lord.
Where's the advertisement? Page number?
Page number 82, annexure 8.
See, drafting is also an art, okay?
Yes, my lord.
Drafting is an art in the sense that you have to make the court understand in the shortest time possible what exactly you want. If you start writing here and there, everywhere, here and there, court will lose patience and you'll not get any order. So you have to be very precise and concise what you want. And without wastage of time, you should be able to project, this is what I want.
Yes, my lord.
Now, see, page 82 is the advertisement.
Yes, my lord.
Which post are you talking about?
It's marking after second paragraph A, department and specialization, my lord. 1, 2, 3, 4. Total 4 posts. In this secondly is mentioned is vacancy marked is 5 posts, my lord, regarding this specific post, Your Honor, my lord.
So what is your case?
Yes, my lord.
All these posts has to be reserved for whom?
In this advertisement, my lord, SC, OBC, and PWD, OBC.
Yes.
The 5 posts is specialized for this special category of the person. So this is the their part of the act, my lord. But in our concern, my lord, since from 2011 till date, my lord, the head of the institute, that means NIT of the head, my lord, in the Union Delhi post, they clearly mentioned that there is a 4-tier system, where clearly mentioned that the 50% of the non-faculty member of the non-domicile of the Arunachal Pradesh, they give the opportunity to file the form fill up, and whatever the advertisement happen, they able and have right to face the interview and got the job. This is their whatever system is there, 4-tier system. But in this case, my lord, the NIT of Arunachal Pradesh never ever do this rules and any kind of the decision made by the higher authority of the Union of India, whatever their NIT's head, my lord, they never ever followed this 50-50 of the ratio, domicile as well as the non-domicile of the state of Arunachal Pradesh.
So this advertisement is for what? General, like that? For everyone?
No general. They make a specific category, SC, OBC, and PWD, not the domicile of the Arunachal Pradesh.
No, that's what. It says SC, OBC, PWD, OBC.
Yes, my lord.
But not necessarily from Arunachal. It can be from anywhere.
They do like that.
So what you're saying is that it should be 50% from outside?
Outside,
and
50%
from the
domicile. As per the concerned authority of the Union of India, what the higher authority of the NITs, my lord.
Where is that?
Yes, my lord. In the main petition, it is clearly mentioned, my lord.
Page number?
Yes. My lord, page number 64. Before starting 64, page number 62, annexure 1. This is the continuation page, my lord.
62?
Page number 62 is annexure 1. This annexure continuation page is 64, my lord, which clearly mentioned that what their concern about the minutes of second meeting on 2011, my lord, which is continuation till date of the 2025, my lord.
No, show me that relevant portion.
Yes, relevant page number 64, item number 2.23, my lord. May I?
2.23.
2.23, page number 64, my lord.
Yes, the council approved.
The council approved the proposal as detailed in the agenda item regarding issuing of an advisory to all the NITs to take action to achieve a target of at least 50% faculty and 25 non-faculty members from outside of home of the state. This is a clear meeting which come under the 4-tier system of the NITs.
To achieve a target of at least 50% faculty.
Yes, my lord.
And 25% non-faculty members.
Yes, my lord. That's true.
From outside the home state.
That's true, my lord.
So insofar as faculty, it's 50%.
Yes.
Insofar as non-faculty members from the home state, there should be 75%.
No, my lord. This is categorized. Suppose there is out of 50% of faculty member. So out of 100%, 50% is directly give to the 50% of non-domicile of the out of the state of Arunachal Pradesh, and 50 remain to the state of Arunachal Pradesh.
That is regarding faculty.
Faculty.
Then non-faculty?
Non-faculty, 25% of the out of the state.
25% from outside the state.
Yes, my lord.
So that is why remaining balance of 75% will be from the state.
From the state, non-faculty.
That's what I was saying. You say no.
Sorry, my mistake, my lord. I humbly my mistake.
What did I say last?
And then after, secondly, my lord, page number 66.
No, it's okay. What did I say?
Yes.
In order to the effect that the recruitment to the post advertised by the advertisement number NIT/AP/faculty recruitment /ADD-01/2024 dated 8/2/2025 should be stayed pending final consideration of the writ petition. In view of the fact that the same is not in line with the decision taken in the minutes in the meeting held by the Council of National Institutes of Technology on 28/6/2011, New Delhi, whereby it is provided that all the NITs should achieve the target of recruiting 50% of the faculty and 25% of the non-faculty members from outside the home state. Stop. In other words, the London Council submits that reservation has been made either for the non-resident applicants or for the persons who are from within the state, as per the state advertisement. Next para. In view of above, issue notice returnable by 19th of December. Mr. Nem Kato, learned DSGI, accept notice on behalf of respondent number 1. Petitioner shall furnish copy of the interlocutor application to him within 2 days. Petitioner is applicants, isn't it? Applicants are permitted to serve notice upon the respondent numbers upon the respondent number 2 by way of Dusty to the registry of this court within a week from today. So the applicants shall thereafter file an affidavit as proof of service. List again on 22nd of December.
My lord, if possible, then Dusty survey should be in the main case also, because the register post is still awaited. So Dusty is very well, because it is 1.5 hours far away this court. In the main case also.
That I know, but the thing is that today the matter is listed, is listed.
Yes, my lord. That's true. It's humble prayer if possible. Because today not get any interim order, at least service of the main case also if serve. Because everything is very crystal clear that.
In the writ petition, please write.
Yes.
Heart, Mr. Your good name?
M. Bagra.
M. Bagra.
Yes.
Learned counsel for the petitioner who submits that steps was taken for service of notice upon the respondent number 2 on 28/11/2025. But service report is still awaited. To stop, he therefore submits that he may be permitted to serve notice to the respondent number 2 by way of Dusty. Prayers allowed. Next para. Petitioners to serve notice to respondent number 2 by way of Dusty within 1 week from today through the registry of this court. Stop, the petitioners shall thereafter file an affidavit as proof of service. List again on 22 December 2025.
Item number 15.
May I plead, Your Lordship? Madam, this IA is for implement Well, in this matter, the petitioner has prayed for payment of outstanding amount, which is admitted amount. But then as per the affidavit of the private respondent, it is as per the affidavit said money has to be released by the Navadya Vidyalaya Samiti. So in this rate petition, we have not made as a respondent. So we wanted the Navadya Vidyalaya Samiti to be one of the respondent in this rate petition.
Yes.
As a respondent.
As respondent number?
Six, yes.
Any objection?
No, Lordship.
Art, Mr. S. Mao.
Lordship, Topi Jini is appearing for Navodaya, Lordship. Topi Jini, Lordship. For Navodaya, she is representing. Yes, but she is not feeling well today. So she has requested me to inform your Lordship that she will be representing Navodaya, Lordship.
Okay.
We will serve extra.
But she has not received the copy.
Learned counsel for the applicant who submits that by filing this application, the applicant seeks implement of, please put S, applicants. Applicants seek implement of Navodaya Vidyalaya Samiti as respondent number 6. Since their implement is essential for effective adjudication of the connected with petition. From Ms. R. Basar, London State Council, submits that she has no objection if the application is allowed. But submits that Ms.
Topi Jini.
T. Jini, who is the standing counsel for the Navodaya Vidyalaya, will be appearing in the case. If Navodaya Vidyalaya is included as a party. So, in view of above, upon hearing the learned counsels and upon perusal of the application for implement as prayed for is hereby allowed. I stands disposed of. In the main writ petition, please write down, in view of the order passed today in IAC number 308 of 2025, allowing the implement of Navodaya Vidyalaya Samiti as respondent number 6, the petitioners shall file the amended cost title in 2 sets before the registry, and thereafter the registry shall do the needful. Next para, issue notice to the newly implemented respondent numbers. Okay, before that, in 2 sets, na? Within
3 days.
Within 3 working days. Okay. Could you get it? The petitioner shall file the amended cost title in 2 sets before the registry of this court within 3 working days. Whereafter the registry shall do the needful. Next para, issue notice to the newly implemented respondent number 6, returnable by 3 weeks. Petitioners shall serve notice upon the respondent number 6 by furnishing the requisite copies of the writ petition along with the amended cost title to Ms. T. Jini,
Yes.
Learned Standing Counsel, Navodaya Vidyalaya Samiti, within 1 week. Of the amended cost title shall also be furnished to Ms. R. Basar, Learned Government Advocate, appearing for the official respondents, appearing for the state respondents. List again after 3 weeks.
After 3 weeks.
Obliged.
Item number 16.
Item number 16 also this IEA. We wanted to, in this matter, direction was that the petitioner land owners who have got compensation, but they have not got the solution. So the now direction was that if they have paid, they should be verified and they should be paid the compensation. But then they have not done yet. Till during that, the deputy commissioner also changed the commanding officer of grief and the secretary MOT. So we wanted to make a new deputy commissioner as a respondent number, contempt number 1, and the BRTF as a Colonel Ajit
Kumar.
as a respondent number 5.
Originally, how many respondents are there already?
3.
How many persons you want to implead? 3 persons.
3 persons, my lord.
3 persons.
Yes.
Now, how do you pronounce the name of this first person you want to implead?
My lord, he is
FWWRMAN.
Yes, my lord, yes.
How do you pronounce it? Burman.
Farman. I think it should be Farman.
Is it a correct spelling or it's type of mistake?
Farman. No, it's correct.
It's correct.
It's correct.
Correct.
Yes. Farman. Brahma.
Heard Mr. S. Mao, learned counsel for the applicants, who submits that by filing this application, the applicant seeks impleadment of 3 additional respondents in the connected contempt petition, namely, number 1, Sri Farman Brahma, IAS, DC Rowing. Number 2, Colonel Ajit Kumar, Commandant 725 BRTF, Rowing. And number 3, Sri V. Umashankar, Secretary, Ministry of Road Transport and Highways, as respondent numbers 4, 5, and 6 in the connected contempt petition. You'll get the names in the first cause title itself. Mr. S. Mount, learned counsel submits that since these 3 persons are the new incumbents holding the posts concerned, their impleadment as party respondent is necessary for effective compliance of the court's direction. Mr. S. Tapi, learned counsel appears for respondent number 1. Anybody else? And Mr.
N. Norbu.
N. Norbu. N. Norbu,
Respondent number 2.
learned counsel appears for respondent number 2. And they submit that they have no objection if the application is allowed. So upon hearing the learned counsels for the parties and upon perusal of the application for impleadment as prayed for by the applicants is hereby allowed. IS stands disposed of.
Lordship, I have a prayer, Lordship. Since in my place, Lordship, new incumbent is being impleaded, so I may be strike off from the Lordship content.
We'll see, not at this stage. You be there.
I have been already transferred to some other place, Lordship.
Maybe.
And there's no such particular allegations against me, Lordship.
It's okay, you be there. See, later on, we don't know. I hope the situation doesn't come to that stage. That court might want to know what you have done while you were holding the position.
That part, already affidavit has been filed, Lordship. As per directions.
But that has not been finalized as yet. Affidavit is there. Contempt is pending. If we keep you out later on, supposing we want to bring you in again.
Yes.
Complications. You'll be there.
Yes,
we'll see.
that's right.
In the long run, we'll see.
Because as per the impleadment application also, there's nothing against my Lordship. My
No, they will not say anything about
my
that.
presence is not
No, you be there.
okay.
Will not strike out at the moment.
Lordship.
It's a reasonable prayer though, but will not strike out at this stage. Please write in view of the order passed today in IAC number 309 of 2025, the petitioners shall file the amended cause title incorporating the new respondents who are to be arrayed as respondent numbers 4, 5, and 6 in 2 sets before the registry within 3 working days. Next para. Issue notice to the newly implemented respondent numbers 4, 5, and 6, making it returnable by 3 weeks. Petitioners to take steps for service of notice upon the newly implemented respondents by registered post with a review within 1 week. List again after 3 weeks.
Item number 18.
May I present, my lord? On behalf of the sole respondent, petitioner of this case, regarding the interim prayer, my lord. The last time also, the steps taken regarding the awaited. My lord, this the story is this, my lord, in annexure 2, page number 18. This is a final order passed by the village authority, which followed by the executive magistrate that there is a land, Pumbang Yulung to Taki Gengtak is by the 2 brothers, Hedu and Hemi clan. The land is very clear, the 2 brothers is owner of the land. Subsequently, what happened, my lord, in the year 2025, this year only, the compensation passed by stretch land from the Pumbang Yulung to Taki Gengtak. The compensation amount will come up. Then what happened, my lord? The 2 brothers between some dispute arise regarding the joint application regarding the availing of the loan compensation amount. But the other Hedu clan is directly denied the same. And subsequently, on 11/6/2025, page number 19, Annex 3 Koli, the petitioner give the complaint application before the deputy ADC and the RRSO regarding the disagreement between the parties regarding the compensation amount. Subsequently, my lord, annexure 4, page number 21.
See, Mr. Counsel, Mr. Bagra.
Yes, my lord.
Matters listed for orders today.
Yes, my lord.
And it seems that the service is not complete on respondent number 3.
Yes, my lord.
You have completed respondent number 3 late subsequently, isn't it?
Yes, my lord. That's true.
Initially, they were not a party.
No, not party. In the beginning, they are not a party.
Why you completed 3 as a new party?
Because, my lord, whatever the case related from the sins from the my annexure 1A, they both the party jointly possess the common land, community land. Then after what happened, the compensation arise, then dispute arise between the 2 clans. Then subsequently the case before the executive magistrate, that is DC of the COME district. Subsequently, an order passed on 8/7/2025 that the whatever the properties except the land, the other gave to the compensation immediately.
Okay. Now,
So-
what is the interim prayer that you're seeking?
Interim prayer regarding this impugn order regarding the 8/7/2025, which enclosed in page number 25, annexure 6 in my petition.
But that is not an interim prayer. That is the final prayer. Final prayer. Interim prayer means like while the writ petition is still pending.
Yes, my lord.
Unless I'm given protection.
Yes, my lord.
I will suffer loss. So give me interim prayer.
Yes, my lord.
This is how they ask. But now here you are asking for modifying, recalling, or cancelling the compensation order.
Yes, my lord. Because we hardly accepted whatever the project is compensation regarding the matter, but they only given a certain compensation amount, not the full amount, which actually in the land, my lord. The person is residing in the land.
So do one thing.
Yes, my lord.
You served the notice by Dasti. They'll be the best. Is it possible?
Maybe, my lord, because
number 3.
2 parties is still some problem is going on. Maybe may not be they receive or not. It's questionable. The register post along with the AD card already served.
Mayor Yopen, president of Hedu clan.
Yes, my lord.
No, AD card has not come back.
Till yet, not yet, my lord.
That is why.
So my prayer is that, my lord, the concerned department, that means deputy commissioner, fully tried that. They already carried their bulldozer, JCB truck to vacated the entire land, which is still they are residing their home, their entire garden, whatever it is, Your Honor, my lord, the petitioner. But they intentionally try to evict it, clear the place, Your Honor. So many losses, maybe physically or their property also. If this is not stay, my lord, they suffer lot of things. So after injury, then what happened? my lord?
Correct. That is why you have no such kind of prayer as such in your prayer portion. You just look at your prayer portion. There's nothing which says that in the interim, give me this protection. What you're praying here is the main prayer. So giving you this prayer, allowing this prayer would mean finally disposing of the writ petition.
But my lord, actually, after the filing of this petition, after few days, the concerned authority aware and they starting the
File one
kind
more
of-
application.
Yes.
File one miscellaneous application or IA, whatever it is, saying that this is the development, this is what happened.
Yes, my lord.
So I need some interim protection like that.
Yes,
You file
my
the application. This will not be proper, na? I mean, this will be the final thing. So in the meantime, you have to serve notice to respondent number 3.
Yes, my lord.
Although you have taken steps, that was only issued on 14th of November.
Yes, my lord.
Hardly 2 weeks.
2 weeks.
2 weeks.
More than.
So do you want to wait for the service report or you want to take Dasti notice?
Both, my lord. Wait, also Dasti also, my lord.
Okay.
And my lord, if possible, if duly obliged, my lord, if till date with they came here, my lord, in the future time, on that short period of time, at least some vacant this order, this stay order, it's possible, my lord.
You have
Because-
to, for that you have to make a proper prayer, not like that, na? Unless you make a prayer like that, how do we pass an interim order? And the same time, unless the person is served also, we'll be only hearing one side of the story. So to speed up things, I'm permitting you to serve by way of Dasti. Serve them. Please write like this. Although notice was issued to the respondent number 3 by registered post with AD due on 14/11/2025, neither AD card nor unserved notice has returned back. Under the circumstance, the petitioner is allowed to serve notice to the respondent number 3 by way of Dasti through the registry of this court. Where is the address?
Address Yomi district, my lord.
How far is that? Within how many days can you serve? Karle village.
Karle village, yes.
Where is it? Where is it? Siomi district.
Yomi district, my lord.
Within how many days can you serve? Dasti.
1 week to 10 days, my lord.
Within 10 days through the registry of this court. Okay. The petitioner shall thereafter file an affidavit indicating proof of service. Just again after 2
If
weeks.
possible, my lord, 22 of this month, the same one or the one case already listed.
Okay, list again on 22nd of December 2025. See, if you want a specific interim prayer or protection, you should file appropriate application
Yes, my lord.
indicating what is the hardship you're going to face.
Yes, my
Court
lord.
will consider and pass. Because as of today, writ petition, you have got few prayers here and there.
Yes, my lord.
So this cannot be granted at this stage, na, unless we dispose of the writ petition.
Actually, my lord, my just hardly prayer is that, my lord. Since for the very so many days, my lord, whatever the I filed, my lord, not gave the instant relief, my lord, because the honorable court thing is that the other party should be heard as per the natural justice, not a single one. So again, the time is goes on, but no any relief get the petitioner, Your Honor, supposed to be.
You will get the relief provided you make a proper prayer by filing appropriate application, Mr. Counsel. Please try to understand.
Yes, my lord.
Yes. That's all.